the petitioner informed that he might get the appointment letter from the authority by 16th of December. So let it be after 6 weeks or not.
Having seen the new year.
As informed by the petitioner.
Okay. Right, Mr.
K. Das for the petitioner.
A. Das, learned counsel for the petitioner, feels that the matter may be adjourned as the petitioner may be given the appointment
Yes.
letter within 6 weeks. To stop accordingly, release this matter in the new year.
Much obliged, Your Lordship.
My lord, I beg to mention item 94, my lord. It's a matter, it's old matter. But
Huh?
I need 1 week time, my lord.
Why? No
I
adjournment
could
matter.
not contact
No,
my
no,
client,
no.
my lord.
No need. Wait.
May before Roshi, a
Huh?
matter from regular list, hearing list. A matter may be taken as daily hearing list from regular list, my lord, who is under dismissal from 2018, my lord.
There is a hearing list.
Yes, my lord. My lord, there are.
Where is the hearing list? I have not seen the hearing list.
My lord, actually, this list is,
There is a hearing list. You've got to file an, there's no hearing list, Mr. Counsel. You file an application for early hearing of a matter.
Like to mention for listening of a pending petition. Like
Why? When was it last listed?
Lordship, 38/2023, Your Lordship. Pensioner benefits have not been given.
Wait for some time. You ask the registry. There's so many matters pending here.
Millard, I have tried for listing of a case, Millard. It was about to be listed, Millard, in the last week, Millard. Matter has not been listed, Millard.
What is for
It
motion?
was about to be disposed of, Millard. The admission stage, Millard. On Friday, Millard. Lordship will kindly bear with me. Friday, Millard.
When was it last listed?
It was last listed on 14/8, Millard.
14/8.
Yes, Millard.
Next week. Give it.
Next week, Millard.
Next week.
On Monday, Millard. I love you. May I pray for listing of some IA lots, 4 IA,
For what?
listing of, along with the writ petition.
IA is for what?
Huh? I-
What is the IA for?
I don't
Next
know.
week. Yes.
Matter will fixed on 16 lots, this 16. Writ petitions.
You don't even know what the IA is for. Next, yes, madam.
Lordship, I'd like to mention 2 matters. One is for motion, Lordship, and the other one for admission any date, Lordship.
Motion is for what?
Lordship, the motion was listed before the vacation. Notice was not issued. The honorable court had directed to be listed after vacation. So any date, Lordship, motion this week.
Next week.
And the admission any date, Lordship.
Next week.
Much obliged.
May I please, Lord? Yes.
Lordship, this petition is Lordship challenging the transfer order dated 3/11/2023, Lordship.
On what ground?
Page is, Lordship, the transfer order is
8/3?
page Lordship 29, Lordship. Page 29, Lordship.
Yes. So,
Yes, 29.
so what is the ground
Lordship, yes,
of
Lordship.
challenge?
This transfer order is not for the public interest, Lordship.
How? Why
This,
do you say?
Lordship, I will explain, Lordship. I will satisfy your Lordship, Lordship. And it is malafide, Lordship. It is malafide and it is in violation of Lordship, the statutory rules, Lordship. I will explain, Lordship. For satisfying, Lordship, first of all, I would like to put your Lordship attention on page number 38, Annexure M, Lordship. I was transferred to Bokazan Sub Treasury, Lordship. This is the stand of Bokazan Sub Treasury. So, Lordship, my post was Senior Accounts Assistant, Lordship. Serial number 4. Cadence strength is Lordship 1, Lordship. And that post is held by the respondent number, private respondent number 6, Lordship. And your Lord, now your Lordship may kindly come to the page number. Annexure A, Lordship. Page 16, Lordship. Order dated 5/11/2022, Lordship.
Yes.
I was promoted, Lordship. My name is shown at serial number 1. I was promoted against the vacant post of Deputy Treasury, Lordship. And the private respondent.
How
was
does it
from-
matter? You've been promoted against so and so, then you get transferred.
No, no,
No case.
no, Lordship, your Lordship may kindly come to the.
What is the ground? How long have
Yes,
you,
Yes,
how,
Lordship.
you have been transferred from which place to which place? From
From
Diffu to Boga.
Bogajan, Lordship. But
Now, how long have you been at Diffu?
Lordship,
How long have you been at Diffu?
Lordship, it is.
Or Dispur or whatever, Dispur.
Less than 3 years. Lordship.
When were you promoted and appointed to that place?
Lordship, on Lordship, 5/11/2020.
5/11/20.
20.
And today is what date?
Lordship.
Today is 13/11/2023.
One thing may
So that means more than 3 years you have been
Lordship, may
there.
kindly come to the page number 24, Lordship.
Heard, Mr.
Kindly come to the page
Are
number
we-
24, Lordship.
No.
24, Lordship. It is again, it is for favoring the respondent number 6.
I do not know. You file a representation. Have you filed a
I
representation?
have filled the
Then
representation.
let them consider that.
I have.
Heard, Mr. R.
Please tell the Lordship.
H. Talukdar, learned counsel for the petitioner, who submits that the impugned order dated 3/11/23 by which the petitioner, who is the senior accounts assistant, has been transferred from
I am 59
Default
years old,
treasury.
Lordship.
Diffu Treasury to Bokajan Sub Treasury.
I am 59 years old at present, Lordship.
Should be set aside, come in as much as the transfer of the petitioner has not been made in public interest, but has been made mala fide. He submit that the petitioner is 59 years of age and he should be allowed to continue in Dispor's treasury till his retirement.
Default treasury, Lordship. Default.
Dispur treasury, Dispur or Diffu?
Default, Lordship.
Diffu treasury. Next, who appears for the other side? Mr.
Here for respondent number 3.
Mr.
D for
D. Bora appears for respondent number 3 and submits that the transfer being in the interest of the exigencies of service, the same should not be interfered with. I have
I have submitted representation, Lordship.
seen the petition. I have seen the representation made by the petitioner dated 7/11/23 issued to the deputy commissioner.
Lordship.
Is there any deputy commissioner now? Division, district commissioner. Issued to the deputy commissioner / district commissioner, Karbi Anglong Diffu, requesting cancellation of the transfer order. And the fact that no decision has been made on the same by the deputy commissioner / divisional commissioner. Next para. In the case of SC Saxena versus Union of India and others, 2006 9 SCC 583, the Supreme Court has held that a government servant cannot disobey a transfer order by not reporting at the place of duty and instead going to the court to ventilate his grievance. Full stop. It is his duty to first report for work where he is transferred and make a representation as to what may be his personal problems. Full stop. Such tendency of not reporting at the place of posting and indulging in litigation needs to be curbed. Full stop. Next paragraph. In view of the judgment of the apex court, as referred to above, the petitioner, this court is not inclined to entertain this writ petition any longer. The above being said, it is the case of the petitioner that he has been working in Diffu Treasury since 6/11/2020, which means that he has been working there for more than 3 years. That is beyond the normal tenure of posting. Full stop. Further, there being no further, the allegation of malafide cannot be accepted, in the absence of any officer being arrayed as a party in his individual capacity in this writ petition. Full stop.
Lordship,
The-
there was some complaint, Lordship, against that Malavadi, Lordship. Complaint was. lodged by
Mr.
the
Counsel,
staff.
the Supreme Court has said that if there's a case of malafide being made out, you have got to put that person as a party in his individual capacity. Where is that?
Lordship, this transfer was made,
Next.
Lordship, pursuant to an application.
In view of the reasons stated above, this court is not inclined to entertain this writ petition. The writ petition is accordingly dismissed. However, the respondent number 3 is directed to dispose of, is directed to examine and dispose of the petitioner's representation against the transfer order, which is transfer order within a period of 10 days.
10 days.
Period of 10 days from the date of receipt of a copy of this order. The decision taken should thereafter be communicated to the petition.
But till that, Lordship, status quo may be maintained, Lordship. Till that, Lordship. Only for 10 days, Lordship, till the disposal of the representation. Lordship.
Yes, till the representation is disposed of by the
Your Lordship, there is a
respondent number
objection
3. Huh?
The order is dated 3/11. By this time, maybe somebody might have joined.
No, not, it is not, no.
If suppose status quo is given, it might create problems.
No, not join, Lordship. I am sure, Lordship. Today itself I have taken the instruction, Lordship.
Let it be just disposed of, your Lordship.
Lordship,
Anyway,
Huh?
Let it be disposed of, your Lordship.
Lordship,
Let the representation
still
be disposed of.
for 10
He
days
may
only,
join in
Lordship.
the new place of posting, even then if it is.
Just right, in the event the petitioner has not been relieved of his post, status quo as on today shall be maintained
Lordship.
till a decision is taken by the respondent number 3.
Obliged, Lordship.
Made privilege. There is an interlocutory application ballot filed for modification and alteration vacation of the interim order dated 27/9/2023,
Even the main writ petition.
which is at page 15, Madam.
Just a minute.
The relevant portion is at page 16, Madam.
You're for the private respondent,
No, my lord, I am for the private dispute
page 16 of your application.
of my application.
Yes, page 16.
Last part, my lord.
Yes.
This is the order. This court has noticed that the input transfer order dated so and so. And by this time, almost 2 weeks have passed. Therefore, it is directed that if the petitioner has not been relieved from his earlier post of posting, a status quo be maintained till the next date. That is on 9/10/2023, my lord. The input transfer order, my lord, is at page 19 of my application. This is an large scale transfer order, my lord. In the district, the 3 ICTS project is there. All the 3 historical instance has been transferred, my lord. The petitioner's only related case is that
Petitioner is which serial number
petitioner is serial number 2, my lord,
and you are
and I am at 1, my lord.
your respondent number?
I am respondent number 6, my lord. Their only related case is that the petitioner has been frequently transferred, my lord. But in fact, the earlier transfer order, my lord, in that case, the petitioner and the applicant on the same date, my lord, they have been transferred, my lord. But subsequently, this last
When was the last transfer order made?
my lord, last transfer order made, my lord, on 15/10 as page 18, my lord. Page 18. This is the petitioner number, writ petitioner is 1 and the applicant is 2, my lord. My humble submission is that, my lord, this present transfer order is a large scale transfer order. In the district, my lord, 3 ICDS project is there. All the 3 ICDS.
Yes, this is for the government.
On behalf of welfare and development and child development. There we are taking the same district. The DC is otherwise empowered to transfer from one particular post master within the same. That is all.
And this is for the interest of public and for the administrative exchange. There is no malafide, nothing. Even then, the distance of the present place of transfer of the writ petitioner and the earlier place of transfer of the writ petitioner from his home place will be the same.
Yes,
May I make my sufficient lordship? If I may take your lordship to the affidavit filed by the respondent number 3.
respondent number
Respondent number 3
in the writ petition.
in the writ petition, lordship.
Affidavit of
Affidavit of
respondent number 2, yes.
respondent number 2. And I take your lordship to running page 31.
Yes,
Now, lordship, this is a communication of 14th October 22.
yes.
Lordship has got it. May I read it, lordship? With reference to the subject cited above, I have the honor to inform you that there are 3 numbers of ICDS projects in South Salmara, Mankacha, wherein 3 numbers of incumbent statistical assistants are working. Sir, through the medium of this letter, I would like to bring to your kind knowledge that since my date of taking over charge as IC District Social Welfare Officer, several verbal complaints have been received against 2 numbers of statistical assistants working in the ICDS projects of the district. On many instances, it appears that they have been exerting dominance in the ICDS projects, which may have enabled them to negatively influence the Anganwadi workers and Anganwadi helpers. Therefore, it may be noted that they have been working in the same ICDS project for a very long time and being localites, they are well versed with the map so and so. Now, on the basis of this recommendation, the transfer order of 22 was passed. The proposal, lordship will find in the next page, page 32. Now, your lordship will take the transfer order of 15/10/22.
Yes,
15/10/22. Therefore, lordship, from the affidavit of the authorities, it is clear that there are some allegations against me. There are some allegations against him also. And on the basis of that, we have been transferred vice versa. Lordship will see the place. Now, by the impugned transfer order, which your lordship will see at page 19 of the petition, what is sought to be done? He is again taken back to the same place
yes.
where there was complaint against him. Again, I have been transferred. Now, lordship, it appears that this is not an order passed in the interest of justice because there was a complaint against him. I do admit there was a complaint against me, but now maybe somehow or other he has tried to manage to influence the authorities to
No,
go back to the same place of
Maybe they found that the
Yes.
complaint doesn't hold any water.
Yes,
lordship. That is not reflected
No,
in
no,
the
but then
order.
where is the question, where is the requirement that it should be reflected? Because once
that-
this, if they have posted you back, then it appears to show that in fact, the
Lordship,
complaint
maybe-
was wrong, the
Lordship,
earlier
within a
complaint.
period of 1 year, lordship, I cannot be made to transfer over and over again, lordship. Lordship will see the earlier order was of October 22. This is of September 23, lordship. In a period of 9 months, lordship, everything has changed. I am sorry, within a period of 11 months. There has to be something before the authority.
Yes, wherever you said that it is in the interest of justice, in the interest of exigencies of service.
And if your lordship will kindly see the opening lines of the impugned order. In partial modification of the earlier order, that is dated 17 July. In fact, there was another transfer order of 17 July, which was not communicated to me. It was not
Yes,
given.
Mr. D. Bora, wherever you said that this is in the exigencies of service.
Lordship, at page number 22, it is stated in the interest of public service of following statistical assessment under South Salmana Market Daily Transfer. What paragraph is it?
Wait,
Page 22. Third line. And. Okay.
so within a span of 1 year, lordship, there are 3 transfer orders. As a matter of fact, although the middle one has not been given effect to lordship.
What is this 17 July 2023 order?
Well, that order has not been communicated, not been given to any other, but not had been given any effect, my lord. So that cannot be taken into account, my lord.
No, it's a continuation of that order, lordship.
And
Yes,
now the
can you bring the records with regard to this 17 July 2023? You just said, let us see. Now, the right. Mr. D. Bora shall produce the records with regard to the order dated 17/7/2023, which is reflected in the impugned order dated 14/9/2023. List the matter when?
No, my lord,
Huh? So,
well, now I am in hanging position, my lord. The person who had transferred in my place has already been joined.
okay, so you don't have a post.
Yes, my lord. I'm in hanging position now, my lord.
Ah, that is also next week.
Next week from date.
Okay,
you
list the
can-
matter on Tuesday next week.
Lordship,
Much of-
Tuesday I will be out of. Can
Okay,
you do
well,
Wednesday?
Wednesday.
Wednesday.
Okay, Thursday, 23rd.
So, lordship, may I pray the interim order?
Interim order to continue to next. You have to file additional affidavit.
Yes.
Lordship, this matter I'm being led by Mr. R. Borpujari in this matter, Lordship. There is a bereavement in his family, Your Lordship, is unavailable. There's a bereavement in his family.
That is all right, but then you see, that is a different thing. The thing is that you have got to file an additional affidavit.
State.
Yes, Your Lordship.
When can you file?
Lordship, kindly fix this matter after 3 weeks, Your Lordship. In the meantime, the affidavit will be filed. Your
My lord, she is not the proper person. Because the affidavit has to be filed by the state.
State and for the revenue department. Your Lordship. State council.
You see, additional senior government advocate has to file it. As per the last order, it was
Mr. Gogoi,
Mr.
Gogoi.
K. Gogoi was to file. Who is where is he? What to do? You call him.
My lord, in that case, let it be listed day after tomorrow, my lord.
Not so fast.
And I would inform you, my.
Okay, right. Yes, additional affidavit has not been filed by Mr. K. Gogoi, learned additional senior government advocate, SM. List this matter in the next week.
My lord, a particular date may I give?
Give a date. 23rd. Why? What? One day? What is the? Why 24th? Huh? We only want the affidavit. to be filed by Mr. Gogoi.
This matter, your lordship, was fixed today for hearing, your lordship. This matters are being conducted by Mr. R. Borpujari. Your lordship, there is a bereavement in his family, your lordship.
Who has died?
His mom, his
His
mother.
mother?
Yes,
Oh.
your lordship, yesterday evening. It's a very tragic incident, your lordship. Lordship may fix this matter after 3 weeks.
Okay,
Interim order is still operating, your lordship. Either ways, they have.
correct. Adjournment prayer has been made on behalf of Mr. R. Borpujari, learned
SC revenue.
SC Revenue, on the ground that his mother expired last evening.
Lordship will not pinpoint this issue, your lordship. It is
Why not?
will be-
Why not?
Yes,
It's a fact
yes, sir.
and it's even they have got to answer to their clients also.
Yes, sir.
So everyone will understand the issue then. The counsel for the respondents do not have any objection to this. So accordingly, list this matter on,
After 3 weeks, your lordship, any fixed date.
give a date. Mr. Sinha, when do you all want?
Maybe on 6th or 7th of December, your lordship. As per to lordship's.
This is a matter on 7th December.
7th of, I'm deeply obliged.
Please, your lordship. My lord, in this case, my lord, about 2 years already gone, my lord, till today, my lord, the respondent has not filed their affidavit, my lord. So, matter may be taken, my lord.
Yes,
Lordship, I appear for the college, Lordship, I appear for response number 4. Lordship, our stand is in page 75, Lordship. No affidavit is required. Lordship. Page 75, our stand is there.
page 75.
Page 75, Lordship.
This is a letter.
Lordship, by the principal.
But they have to get the UGC pay scale.
Lordship, the issue here is, Lordship, she has obtained her MPhil from Vinayak Mission University in 2009 and PhD from Singhania University, Rajasthan in 2013. And the college has taken a stand that she has taken sufficient leave and it is a genuine degree. Now, Lordship,
She has taken sufficient leave.
sufficient leave for that purpose.
Ah.
Lordship. Because earlier she was acting on ad hoc basis.
Ah,
Now she was regularly appointed.
ah,
Now, Lordship, the department, that is higher education department, is making objection that, Lordship, there is maybe some doubt with regard to your PhD degree.
So?
And
no,
Lordship,
but
there are-
who is for the government?
yes, the government, Lordship, was directed to file affidavit, but they have not. And her name also appeared in the
2 times, my lord, already verified my document, my lord.
But who is appearing?
And Lordship, in fact, Lordship, on earlier occasion, this honorable court has asked whether her name appeared in the list of the candidates where a paper publication was made. In that
paper, in that list also our name appear. Mediator.
My lord, first going through my lord, page 47, annex 10, my lord, office memorandum. my
Where
lord.
is the newspaper?
Newspaper, my lord, it is my lord, total 354 candidates' name were published categorically in a newspaper on
No, no, where
January.
is the advertisement?
Advertisement, my lord, I am doing. It's my lord affidavit in opposite, additional affidavit, my lord. In my additional affidavit, I have filed the advertisement. Page 81, my lord, in my additional affidavit.
Okay. Where is the council for the higher education department? What to do?
My lord, I'm calling.
Next.
Or Lordship may kindly give them one more chance to file their affidavit because in on earlier occasion also Lordship it has been reflected that they should file their affidavit.
They have been made to pay cost also and they have paid cost
Yes, my lord.
also. Then how much more time will you give? Yes,
I'm calling, my lord.
My lord, in item 39 on appearing draft of Rita Devi, my lord, she is in like in question number 6, my lord, can you take it up at 2, my lord?
that's good. Yes, what is your case, madam?
Lordship, this is regarding family pension. Lordship, my son expired in an accident.
Your son expired in accident,
Yes,
then
Lordship, and his wife and I am only the two next of kin. So
in the while the wife is still alive, why should you get any family pension?
Lordship, my only son and I was
How
dependent
does
on
it,
him.
where does,
He was
where,
taking care of me.
who is appearing for the wife? Yes, what is your,
So I'm refuting.
Huh?
I'm refuting to her prayer.
no, on what ground?
The ground that she is not entitled.
Not entitled under 143.
Yes, until my death. But my lord, the AG was directed to file the affidavit.
Not required, let's see. Sure, let us see the law.
Page number. must be-
The new book, my lord, is 158. 158.
This book,
That is it, my lord. But
158.
The amendment has been inserted in the.
That is a different thing. 158.
158.
158 page number.
Yes, madam. No, now where does it show? That first it will be the wife who gets.
Finally, for the purpose of rule 143, this section will include the following relatives. So the first is wife, initiative of main officer. Now,
That is all right.
yes,
That's all right. But where does it say that who will get what, who will get the family pension first?
the amendment, my lord. Amendment of one, rule 143, small one. The following provisions are included in the rule 143, and 2 of the Assam Services Pension Rules 1969 in line with the All India Services.
Yeah,
So the amendment is there.
I know. So where does it say that first it will be the wife who will get, then it will be the children who will get? Where does it say that?
My lord, see, for the purpose of this rule, family shall include the following. Now, father and mother has been included.
Yeah,
Now, my lord, number 3. Family pension under this rule shall be admissible to the following provisions of 143(2) of the Assam Services Pension Rules 19, apart from A to C in the existing provision. To the father, failing D to the mother.
correct.
Now, before that, my lord, A to C and A, my lord. Why?
Now, where does it say failing A, B will get, failing B, C will get? Yes, madam. Where is where is the provision supporting your case that you should get a part of the pension along with the wife?
Lordship, this is a family pension I am praying
No,
for,
no,
I know.
no.
And the
You
wife,
you come to 137.5. Come to 137.5.
well,
137.5. This section 3 deals with family pension. A pension sanctioned under this section will be allowed to the eldest surviving widow if the deceased is a male officer, or to the husband if the deceased is a female officer. Failing a widow or a husband, as the case may be, to the eldest surviving son. Failing to the eldest so.
This is there, the last, fifth one,
Page.
page 160, last.
Yes.
The provisions of this notification shall cover all cases of family pension, irrespective of the date of death of the person. Pension awarded under the rules in this section will not be payable to more than one member of an officer's family
Yes.
at the same time.
Yes.
Which part the agreement below. And Thereafter.
Yes.
And so on.
Yes. So, madam, no case. Heard Miss M. Vora, learned counsel for the petitioner. Also heard Mr. Huh? P. Bhardwaj, learned counsel for the respondent number 4. And Mr.
R.R. Gogoi
R.R. Gogoi for
for the Forest Department, Lordship.
the forest department. Anybody else? Mr. Mr. S.R. Barwa appears for respondent number 5. Full stop.
Family pension. Family pension, how?
Next para. The petitioner's case is that she is the mother of the late Roop Jyoti Bora, who had served as a constable in the 2nd Assam Forest Protection Force Battalion. Full stop. The petitioner's son passed away in a motor accident on 2010-2021, while on duty. Full stop. The petitioner's son left behind his wife, that is the respondent number 4, and the petitioner. Full stop. The petitioner's son did not have any children with the respondent number 4. Full stop. Next para. The grievance of the petitioner is that the respondent number 4 has left the marital home and is not sharing a part of the pension, is not sharing the pension, family pension received by her. Full stop. That,
But if she's working in the same department,
how does it matter? Who's working in the same department?
doesn't matter, Lordship.
Who's working in the same department?
The wife.
Full stop. Further, the respondent number 4, bracket wife, is working in the same department as her deceased husband. As in the same department that her deceased husband had been working in. Full stop. Next para. Mr. No, she accordingly submits that the petitioner should be given a proportionate share of the family pension along with the respondent number 4. Full stop. Next para. Mr. P. Bhardwaj, the learned counsel for the respondent number 4, submits that in terms of Rule 143 of the Assam Services Pension Rules, 1969, hereinafter referred to as the 1969 rules, the mother would have no right to pension, would have no right to grant of family pension as long as the respondent number 4 was still alive. Full stop. Any submission from your part, from the state respondents? No. Full stop. I have considered the submissions made by the petitioner's counsel and the respondent number 4's counsel. Full stop. Rule 143(1) of the 1969 rules defines family. Now, Rule 43(1) and the amendment made thereto defines family to include the following relatives of a government servant: A, wife, in the case of a male officer; B, it's here at page 158, A, B, C, D. Okay. Then at page 158 itself, E, F, G, H is also there. Okay. I'll just mark it in there. 158, 159. Full stop. Next para. Rule 143 bracket Roman 3 small provides that pension awarded under the rules in this section will not be payable to more than one member of an officer's family at the same time. Full stop. it will first be admissible to the widow slash widower and thereafter to the minor children. Full stop. It is okay, page 160, 161. Then also where is that portion where it says that the mother will get after the death of the father?
Another amendment, my lord.
Acha,
Amendment, Lordship.
full stop.
Part
Further,
three, number 3.
further, the amendment provides that family pension under Rule 143 shall be admissible apart from A to C in the existing provisions as follows, comma. I'm making it X. This X. Full stop. That is at page 158. Full stop. A perusal of the above clearly goes to show that family pension can be given to only one member of the family of a deceased government servant, and that the family pension would have to first be given to the widow slash widower. Full stop. Thereafter, in the event of death of the widow slash widower, it shall have to be given to the minor sons, and in the absence of the same, comma, to the unmarried dependent daughters. Full stop. In the absence of unmarried dependent daughter, it would have to be given to the father, comma, failing which, to the mother. Full stop. And so on. Not full stop, and so on, but full stop. As such, Rule 143 of the 1969 rules, along with the amendment, makes it clear that
Lordship, note 2 also can be included.
not true.
2.
What have I said? That the mother, comma, that is the petitioner herein, does not have any right to claim a proportionate share of the family pension that is being given to the respondent number 4, comma, that is the wife of the deceased government servant. Full stop. This is also in line with subsection 5 of section, oh no, not subsection, sub rule 5 of Rule 137 of the 1969 rules. Full stop. In view of the reasons stated above, comma, this court does not find any merit in the writ petition. The writ petition is accordingly dismissed. In view of the order passed in the main writ petition, the I is also accordingly disposed of.
Lordship, hearing this matter, we have received instruction, Lordship. I seek some time to file my affidavit.
When did you receive instructions?
Lordship, on 4th of November, Lordship.
4th of November.
Last occasion also they paid for that instructed that they already received the instruction, my lord.
No, we have not said that. Right, Mr. D. Upamanyu,
Yes, Lord.
learned counsel for the
Higher Education Department.
Higher Education Department submits that he has received instructions and will be filing affidavit in a position within
A week, Lord.
a week on behalf of
Lordship.
the Higher Education Department.
Director.
List the matter after a week.
Did matter, my Lord,
Give a date.
my Lord, 24.
After that. Next.
My Lord, 24.
Huh?
Like, sir.
20?
24.
These cases relate to compassionate appointment. Already cases. Combined affidavit has been filed by them, Madam. I'm indicating there. Common affidavit has been filed, Madam, in these cases pursuant to an order passed by this Honorable Court on 24th of August 2023 in one of the written petitions, that is WPC 5086. The common affidavit we have filed. If they want to respond, they can respond, Madam, or I will file the response. Copies have been served to many of them, Madam. Others.
What is the issue here?
Compassionate appointment, Madam.
Yes, I know, but what about it?
Issue is where their case, most of the person's cases were rejected. Either they came late after 5 years, 10 years, some are after 19 years. And otherwise, my lord, earlier 2009 scheme was there for compassionate appointment. From 2017, my lord, we have come up with a new scheme under which there is no compassionate appointment, but then we paid full salary till the date of retirement of the deceased employee. And after that, family pension. They claim to be persons before that, so as to claim appointment. This is the issue.
And my lord, in most of the cases, my lord, probably when lordship has to decide, my lord, all individually the case has to be scrutinized. Otherwise, my lord, one issue or two issues may be the different issues in most of the cases, my lord. So, my lord, in this case today, my lord, I pray, my lord, to file a reply, my lord, 2 weeks time may be granted.
Lordship,
We have not received the affidavit, your lordship, so when.
One will get, ma'am. No difficult.
Email IDs and WhatsApp. We should have to let them copy, then only we will be able to reply them.
Lordship, I would like to make a prayer in item 75, my lord. My lord, in the case, my lord, what had happened is that I had tagged the matter a bit later, because of which, my lord, there is a status report filed regarding the cases, regarding their rejection and everything. But mine has not been, my report has not been pinpointed, my lord, in the said affidavit filed by the respondent. If today I had a word with my senior from the opposite side, Mr. Arnold, he has told me that a separate affidavit may be filed for my case. Otherwise, I am left out, my lord.
This may be segregated, my lord. First, he has come later on, my lord, he has tagged the matter. By that time, my lord, that honorable court order was already.
No, why is your issue different?
It's same, my lord.
Then?
Compassion point.
Then?
My lord, but in the status report, it is not there. There is the annexure 1, my lord, which has been appended by the respondents. My case is not mentioned out there. Rest of the cases are there.
We'll file a separate matter. My lord will just segregate.
Item 75.
75, my lord.
Segregate matter. This matter.
WPC 2076 of 23.
Right. Mr. R. Mazumdar, the learned additional AG, submits that affidavit in a position, a common affidavit in a position has been filed. Mr. D. Mazumdar, the additional AG submits that a consolidated common affidavit has been filed. Full stop. No, comma, to which the respondents councils pray for how much time?
2 weeks time.
2 weeks time to file a reply affidavit. Full stop. The same is allowed. Full stop. Next para. Mr. R. Dhar, learned counsel for the state respondent submit that a separate affidavit will be filed on behalf of the government in respect of WPC number 2076/2023. Accordingly, list this matter after 2 weeks. In the meantime, the state respondent shall serve copies of the affidavit in a position to all the writ petitioners, to all the councils for the writ petition.
My lord,
Within
within a week,
within a week.
My lord, may I make one prayer, last prayer? My lord, in 2076, if on the next occasion the affidavit could be filed, my lord, then I'll know about my data. Then I can.
Mr. Dhara, how much time will you file it for the 2076?
We haven't received any instructions as of now, my lord, in this matter. Let's come after 3 weeks, my lord, we segregate this matter, my lord, from this branch file.
my lord, in fact, once your lordship decides these issues, this can be decided on the basis of that, so there will be no difficulty.
Okay, right. Registry to segregate WPC number 2076 of 2023 from the present batch of cases.
Right.
Then you write, list all these matters after 3 weeks.
My lord, my method.
Huh?
If I am segregated, sir, when will it be listed?
List this matters on your date.
But they can kindly serve as a office, but they
Huh?
are giving. A copy of the counter affidavit is not ready.
I
That-
told
that-
them.
That may be.
I told them.
Hopefully.
I've said it in the order.
Lordship, I'm
Yes,
appearing on behalf of Mr. P. Mahanta. With the consent of the other side, your lordship, I pray the matter may be adjourned for the day.
appearing on behalf of Mr.
P. Mahanta, your lordship.
P. Mountain. What has happened to the departmental proceeding?
My lord, the inquiry is almost complete. It is likely to be submitted any day.
Wait for a short date, your
So
lordship.
it will become infructuous, this matter.
That way it will become.
On the prayer for a genuine made on behalf of Mr. P. Mahanta, learned counsel for the petitioner. This is the matter after
1 week, your lordship.
a week.
Much appreciated.
In this case, on the last occasion.
No affidavit.
No affidavit has been filed.
We received the instruction lordship. So we are going to file our affidavit.
When?
3 weeks lordship, by the time we will file it.
Mr.
P. N. Sharma.
P. A. Sharma, learned standing counsel. Then you have said on the last date also.
Lordship, no, the appointment letter was not received on the last occasion. Only the instructions were received. Concrete instructions were not received. Now that lordship, the appointment letter has been also received. And the petitioner had accepted the terms and conditions of the appointment, which was given prospective effect, lordship. And after accepting the terms and conditions, he had joined, lordship.
Mr. P. N. Sharma, learned standing counsel for the school education department submits that he could not file the affidavit in opposition earlier as he did not receive the
Concrete instruction, lordship.
he did what is the appointment letter?
Appointment letter
As-
and the joining letter.
He did not receive the appointment letter and joining letter along with the instructions earlier. So, sir. However, as all the documents have now been received by him, he'll be filing affidavit in opposition within
2 weeks, lordship.
3 weeks. List the matter after 3 weeks.
Obliged, lord.
May it please the lordship. My lord, the matter relates to recruitment of my lord junior engineer by the Public Works Department, Government of Assam. Now, my lord, the dispute is regarding whether the core branch of civil engineering includes, my lord,
Whether the
core branch of civil engineering.
branch.
Core branch. CORE.
CORE.
Core branch of civil engineering includes, my lord, civil engineering and planning. That is the issue, my lord.
whether the core branch includes civil
Engineering and planning. My lord, the.
and your case
we
is
are-
that.
We are all, my lord, civil engineering and planning.
Okay. So you want to be included there.
Yes.
You
Whatever
say that
other,
you
my lord,
are
our
included.
cases were not considered by the Public Service Commission. because we were not civil engineering per se. That is the case.
So APSC did not consider you.
Yes. In fact, my lord, in the initial screening, where names were there. But subsequently, my lord, when a list of qualified candidates was published, there our names did not figure. That is how we are before our lordships. By interim orders, my lord, our interests are protected. Now, my lord, if your lordships kindly comes to the advertisement, my lord, page number 63.
Which writ petition?
5355. 82, my lord.
Page 82.
63, my lord. This is the advertisement which was issued by my lord, Assam Public Service Commission. Assam Public Service Commission invites application from Indian citizen as defined in so and so for the undermentioned post and Government of Assam in this scale of so and so. Next page, my lord, page 64. B1. Name of post, junior engineer civil under Public Work Department, 307 posts. If you lordship to kindly come to serial 5, my lord.
Yes.
Educational qualification. The candidate must have passed 3 years diploma in civil engineering from an institute recognized by Government of Assam. Now, my lord, will kindly come to page number 261, my lord.
Yes.
This is an office memorandum issued by the Government of Assam in the technical department, my lord. Kindly see, it is 13th of July 2017. In pursuance of Rule 8 of the Assam Technical Education Service Amended Rules 2008, Government of Assam is pleased to adopt the AICT's latest prescribed qualification by so for major core branch of engineering colleges for recruitment to teaching position in the engineering colleges of Assam as noted below. Kindly see, my lord, civil engineering, corresponding core civil engineering, relevant appropriate nomenclature, building and construction technology, civil and rural engineering, civil engineering and planning. So Government of Assam has already notified.
No, so these persons with building and
My lord,
building and construction technology, all these persons were allowed to take part or not?
yes, no, we are not concerned here in this case with building and construction. We are concerned in this case with, my lord,
Civil engineering.
engineering and civil engineering and planning. Now, civil engineering is the major core branch, and these are all, my lord, appropriate nomenclatures which can be used. Civil engineering, be it civil engineering, be it civil engineering and planning, be it civil engineering construction technology, these are all civil engineering. Am I clear to your lordship?
What about the next column? What is this?
Next column is, my lord, relevant appropriate no in PG. This is for postgraduate.
Okay, this is
Now, in fact, my lord, I'll give the background. Earlier, there were 2 years diploma, my lord. How subsequently?
No, you see, civil, just a minute. Major disciplines of engineering, civil engineering, agriculture.
Yeah.
And then corresponding course of engineering, technology, civil engineering.
In other words, my lord, civil engineering would include all this in column number 3. If somebody is even a building and construction technology also, then also, my lord, he has to be constituted as a having diploma in civil engineering in all these columns. And this is issued by the government of Assam itself. Merely
This
because
this is diploma or how do you say?
we are
it's dip-
concerned with diploma. It's same thing, my lord.
whether- Is this relatable to diploma pitch
Yeah,
261?
everything, my lord, be it degree or diploma, same thing, my lord. Advertisement is at page 64. Page 63 it starts. And the relevant portion is at page 64. A candidate must have passed 3 years diploma course in civil engineering from an institute recognized by the government. In fact, in subsequent advertisement, my lord, they have advertised civil engineering and planning. That also we have brought on record. Same public works department. Then, my lord, the APSC filed an affidavit. In the affidavit, the stand taken is that since in the draft advertisement, only civil engineering is given, therefore they have not acted on the civil engineering and plan. That is their stand. Anyway, my lord, the duty of Public Service Commission is to make selection. It is the requisitioning department whose role would be more important. It is the Public Works Department, their say is vital. Public Service Commission do not have any, lease in this matter. They have been asked, they are a specialized body. They have been asked by the government of Assam in the Public Works Department to make this selection, and they have made this selection. They should neither have any stand in this matter, nor neither to support or not to oppose. All of in an appropriate case, if any allegations are made, then it is different. Now, my lord, if Public Service Commission has filed an affidavit that your lordship will get at page number 264. And I'll have your lordship's kind attention to page 278.
Yes.
Now, this is the draft advertisement, my lord. They are relying on this. Please come to 8.
Yes.
Educational qualification, candidate must have a diploma in civil engineering from any technical institute recognized by the government. Now, their stand is, because in the draft advertisement only civil engineering is mentioned, therefore civil engineering and planning cannot be considered. That is their case. Why they say so? They have given some justification, my lord. If your lordship will kindly come to page 281. This is one of the minute, my lord, at page 281. Minutes of meeting held on 11/1/23 in the office chamber of Secretary, Higher Education Department, in presence of officials of chairman. So, my lord, kindly see, my lord, Bonosri Nath is an ACS officer. Madhusudan Nath is an ACS officer. Pubali Guha is an ACS officer. Sandana Mohanto is an ACS officer. Dhubojoti is an ACS officer. Only, my lord, Indrani Gogoi is a training of so-and-so. Then Dr. Jahanur Rahman is a lecturer. Anjan Burman lecturer, so-and-so. Now, they say, my lord, in this meeting, if your lordship would kindly come to the last para. Therefore, the meeting reads the conclusion that the two courses are not interchangeable and substantially different from each other. The meeting ended with a vote of thanks from the Secretary, Higher Education, Government. Now, my lord, who is the nodal agency? It is the All India Council for Technical Education. Because, my lord, standard of higher education in terms of NP 66 of list 1 of the 7th schedule of the Constitution, it is not these ACS officers who will determine, my lord, what civil engineering includes. It is for the All India Council for Technical Education to lay down this standard, and they have laid down in favor of us. And in the subsequent advertisement, they have relied upon, they have said civil engineering and planning. Now, my lord will kindly take our.
Where is the subsequent advertisement?
Yes, please come to the rejoinder, my lord. Filed by us. It starts at page 94.
94.
294, my lord. 294. The subsequent advertisement is at page 366. (366). During the pendency of this case, my lord, this advertisement has been issued. Dated 15th of March 23. Kindly see the name of the post, Junior Engineer Civil, under so and so Public Works Department. Kindly come to serial number 6. Candidate must have a diploma in civil engineering / civil engineering and planning from any tech. Has the lordship got it right?
Out here, name of post is junior engineer.
Yes, my lord. Here also junior engineer, civil.
No, in the earlier one, was assistant engineer.
No. That was first one, my lord.
Okay.
Please come to the next page.
Okay, junior engineer.
307. Civil engineering / civil engineering and planning. That is one and the same. Now, my lord, we have brought on record certain documents which are vital bearing in the adjudication of issues, which I'll refer to this, my lord. I mean, rejoinder affidavit. My lord will kindly come to page 316. That is the AICTE's Gazette notification. Please come to page 316. So this is the authority in terms of the constitution who decides, not few ACS officers, my lord. In exercise of the power conferred under subsection 1 of section 23 read with section 1014 of the All India Council for Technical Education, so and so makes the following regulation. These regulations may be called All India Council for Technical Education Major Core Branch of Engineering Technology and the relevant appropriate courses leading to degree in Engineering Technology 2017 for recruitment to teaching position. These shall apply to technical institutions conducting technical educations and such other programs as notified by the council from time to time. They shall come into effect from the date of their publication in the official gazette. 2. Major core branch of engineering and technology with nomenclature of undergraduate, postgraduate degree relevant for recruitment in teaching position in technical institutions are hereby notified in the annexure. My lord will kindly come to the next page, page 317. Kindly see on top, my lord, civil engineering. Kindly come to the third column. Serial, not serial, but chronologically third one. Civil engineering and plan. So major core branches, my lord, civil engineering, and appropriate branches, it could be civil engineering, it could be civil engineering and plan. Then my lord will kindly come to page number 320.
Yeah.
Please come to C, my lord. Merger of certain courses in engineering and technology in undergraduate degree and diploma is permitted as per the guidelines given in Annexure 6 or 7 of the approval process handbook as per different specialization of MBA is permitted, so that the intake after merger shall be equal to the sum total of the individual councils and divisions, provided the faculty student ratio be maintained. Partial merger of division is not permissible. Now, for example, if an institution offering courses such as computer science and engineering and software engineering, both the courses shall be merged either to computer science and engineering or software engineering. So either would be, my lord, it would be, a courses in computer science, be it computer science and engineering or software engineering. So this is an example, my. Then my lord will kindly come to page number 322, which is very important, my lord. These are all by the AICT. In exercise of the power conferred under subsection 1 of so and so, so and so, so and so, I'll have your lordship's kind attention to the first subpara. Keeping in view the contents of the aforesaid gazette notification, the difficulty is being faced by various job seekers and government organization in taking decision for recruitment of candidates for various posts having qualification in engineering and technology at degree and PG level, and also provision made in the new national educational policy about multidisciplinary and flexibility. It is hereby clarified that the aforesaid organization should take into consideration list of major discipline of engineering technology and the relevant appropriate branches with nomenclature of UG PG degree as notified while deciding the core branch and allied branch. So my lord, while this whether a allied branch should be included in the core or major branch, well, it is necessary to refer to the AICTE gazette, which says civil engineering includes both civil engineering and planning. Then my lord, how this 3-year course was introduced, please come to the next page. The one we got, my lord. This is the Government of Assam document, my lord. Page 323. Earlier it was 2 years. Introduction of a new diploma course, civil engineering and planning at Girls Polytechnic, Guwahati. We have passed out from this institute, my lord. It's a government institution. A new 3-year diploma course, civil engineering and planning, has been introduced in place of previous 2-year certificate course on civil engineering and draftsmanship. In the 2-year certificate course, student had to study draftsmanship for 2 years and also cover most portion of the civil engineering diploma course. And after successful completion, they used to get only get a certificate, which did not carry good demand in job market. Most of the pass out found it very difficult to get jobs, not to speak of good salary. In the new course, civil engineering and planning, in addition to the course content of 3-year civil engineering diploma course, we have included topics on architectural design, architectural bylaw, etc., along with planning. The syllabus for the new course has been examined and finalized by Dr. Bibha Das, head of the department, Civil Engineering, Department of Assam Engineering College. The new course has been started from 2004 after getting approval of AICTE with intake capacity of 30 students every year. In 2004 and 5, the capacity was almost full, and in 2006, it is completely filled up. So there is a great demand for admission into this course. So this is the background, my lord, how this 3-year course of civil engineering and planning was introduced. Then my lord will kindly come to page 325. This is a 325, my lord. It's an order issued on 2013. Now onwards, 3 years diploma course in civil engineering and planning branch will be treated as civil engineering branch as it prevails in other polytechnic of the state.
Will be, doesn't say
Treated. Will be treated, my lord.
No.
As civil engineering branch as it prevails in other polytechnics of the state. The course structure and others will be same as existing course structure of 3 years diploma course in civil engineering in the state of Assam. So this is none other than by the Director of Technical Education, Assam. Then my lord will kindly come to next page, page number 326.
Just a minute.
Yes.
There is that word treated is not here.
My lord.
That word treated is not here.
My lord, this is not typed out properly. My lord, otherwise it makes no sense, my lord. Now onwards.
Maybe, but then the words are, not add words that are
We'll
not
try,
there.
we'll try to obtain a original copy, my lord. Lordship may leave it there. We'll try to get it and hand over a copy. My lord will kindly come to page 326. Now, this is very important. Kindly mark the date, my lord. 10/3/22, and kindly see it is issued by the Director of Technical Education to the Secretary Assam Public Service Commission. My lord, they need not set up their committee, my lord. They could have referred to this document to find out whether civil engineering includes civil engineering and planning. Kindly see, my lord. With reference to the subject cited above, I have the honor to state that as per AICT's notification and Assam Government Office Memorandum mentioned under reference, Diploma in Civil Engineering and Planning may be considered as equivalent to Diploma in Civil Engineering. Diploma in Civil Engineering and Planning belongs to core or major discipline of civil engineering, which is as per nomenclature of UG and PG degree in engineering technology as shown below. Kindly see, my lord, civil engineering and planning. Now, why APSC did not consider this, my lord? Why they constituted a committee of ACS officers to find out whether the two subjects are different? Can you see the fun, my lord? How they're misusing their power. What business Assam Civil Service, Public Service Commission has got, my lord? Their task is to make this election. That's all. If they have any difficulty, they could have referred to this document.
Yeah.
Yes, my lord will kindly come to now page 327. From Propositive Bora, Director of Technical Education to Secretary, Assam Higher Education. My lord will kindly come to paragraph subject. Equivalence of diploma in civil engineering and planning to diploma in civil engineering. We are concerned with this. It includes others also. Kindly see, my lord, serial number 3. Concerned state government department recruiting diploma have not considered diploma in engineering discipline having any other corresponding relevant nomenclature other than the major core discipline of engineering. That means, my lord, the Director of Technical Education brought it out to the notice of the Secretary in the Higher Education that the departments are considering only the major and core discipline while ignoring the, my lord, other corresponding branches. Therefore, my lord, kindly see page 328. It is therefore suggested that different nomenclature of various discipline of engineering technology may be brought under major discipline of engineering technology, commonly known as for equivalence, as per AICT approval process handbook 2022-23. In view of above, I am reading the last subpara. Government may take necessary steps towards issuing a government OM in line with Assam government dated 13 July 2017, which was related to undergraduate, postgraduate courses in engineering colleges. My lord, this 13 July 2017 is perhaps, my lord, so, my lord, the director said, as you have done in case of undergraduate and postgraduate, please issue an appropriate OM in respect of diploma. Then, my lord, will kindly come to page number 334, my lord. 334. One of the petitioner. My lord, this is an RTI application by one of the petitioner asking the PHC department whether any diploma in civil engineering and planning has been recruited by your department? Am I clear, my lord? Pune. Someone, not a petitioner, but someone else, my lord. Can we see, please provide me the following information. Is there any junior engineer civil presently working under your establishment having diploma qualification as 3-year diploma in civil engineering and planning, and whose recommendation was made by Public Service Commission? So that was the query, my lord. Please come to the answer at page 336. Junior engineer civil presently working in public health engineering department with diploma in civil engineering and planning. So these are the, my lord, 412 with civil engineering and diploma working in, my lord, PhD department. PhD.
But we are interested in PWD.
Yes. Yes. Then my lord will kindly come to 345. Similar, my lord, query was made with water resource department, because these are the engineering department, works department of government of Assam. PWD, irrigation, water resource, and PHC. These are the 4 works department. At page 345, lordships will find an RTI application was made with the water resource department, and the answer is starts at page 346, my lord. Yes, number of such employees presently working under water resource department who have diploma qualification as 3-year diploma in civil engineering and planning, whose recommendation was made by APS. So query was twofold: whether anybody with diploma in civil engineering and planning is recruited by you, and whether the selection was made by APS. Answer is in the affirmative, yes. Then similar application was made at page 347 to, my lord, irrigation department. 347. And answer is at page 349. As received from the controlling authority, total number of junior engineer civil working in irrigation department having diploma in civil engineering and planning and whose recommendation has been made by Assam Public Service Commission is 7. Same Assam Public Service Commission. Then my lord will kindly come to page 350. This is an approval given by, my lord, AICT. Kindly see, my lord, at page 350. Extension of approval to Girls Polytechnic, Government of Assam, for conducting diploma level courses for academic year so and so. Serial number 3 is the subject matter in respect of the Guwahati Institute, from which all these petitioners have passed out. Girls Polytechnic, Guwahati. Serial number 3, diploma in civil engineering. Then, my lord, I will refer to some communications from the AICT, my lord, to all secretaries of government of all different governments of states and union territories. Now, despite that 2017 of Gazette notification issued by AICT, my lord, there were some, my lord, there was no uniformity in the actions taken by the states and union territories. So, my lord, they had to reiterate their position. This is what will follow. At page 353, dated 23/10/2020. You are aware that All India Council for Technical Education, by its notification dated 28th of April 17, has already published Gazette notification regarding major core branch of engineering and technology with nomenclature of UG PG degree relevant for degree recruitment in teaching position in the technical institution. In spite of the above, this council received a large number of grievances from faculty members, requests from governments, PTs pertaining to eligibility, etc., etc. So these are the queries which they were receiving. Now, last sub-para, my lord. In order to resolve these issues, further the ICT has now come up with clarification and equivalence, relevance or appropriateness of nomenclature of degree in engineering and technology for recruitment to teaching position, promotion, CS in the same or other institution, university that has there. This will go a long way to resolve and set aside the ambiguities offered due to various nomenclature among relevant branches of engineering. Now, my lord will kindly come to page number 358. Page 358. First sub-para, my lord. For example, many representation has received from different parts of the country. Here are some illustrations. Please come to the last serial 4, my lord. BTech degree holders in civil engineering, that is building and construction technology, civil and rural engineering, civil engineering and planning, civil engineering, construction technology, civil and infrastructure engineering, civil technology, construction engineering and management, or etc. Management so and so. Please skip over to the next page, my lord. Are not considered in any other department than in department with exact name, although all these degrees nomenclature belong to major discipline of civil engineering. Then my lord will kindly come to page number 361. Having regard to the, my lord, ambiguities which was prevailing, now what was suggested was this course of action by AICT. It is again hereby advised to follow the regulation issued by council, wide notification dated 28/4/17, my lord. This is at page 316. This notification dated 28/4/17 is at page 316, my lord. And 1319 is at page 363. 316 for a moment, my lord. Straight away, please come to page 317, my lord. Civil engineering, so it includes all this, my lord, appropriate relevant branches. Major core branches, civil engineering, the rest are all appropriate relevant branches. Similarly, if your lordship would kindly come to page 363, my lord. So here also it reiterates about 28/4/7. So eventually at page 366, my lord, a subsequent advertisement issued by the Assam Public Service Commission, my lord, in respect of Public Works Department, where now they have said that civil engineering / civil engineering and planning. Therefore, my lord, having regard to all this position, my lord, and not considering our case was wrong, now their APSC is bound to consider our case, my lord, because as I have already submitted, my lord, it is the duty of AICT to lay down the standard of education. And they have done it by notification dated 28/4/17 at page 316. So now over that, my lord, APSC has no business to seek in appeal over that and try to find out whether civil engineering and planning are one and the same. Their only duty is to follow the expert's view. Even this honorable court is not an expert, my lord. It is the appropriate experts in the field who have already said. And therefore, my lord, this whole selection has to be redone, my lord. And by an appropriate interim order, our interests were already protected. Now, therefore, my humble submission would be, my lord, in terms of our prayer, our cases should be considered by the APSC for selection as if we have the qualification. Earlier, my lord, our cases were not considered on the plea that we do not have the appropriate qualification. That is my case. কোনটো কেছত my lord, in another matter, in the same series, item number 2. WPC 2064 to the other.
Item number?
I'm giving the WPC 80, my lord. 80. 80.
2064.
Yes, my lord. In that, if in that case, my lord, in the affidavit, PWD has said is one and the same. The requisitioning department is saying, my lord, in respect of the same case. No, it is my appointment to meeting.
206.
Yes. My lord will kindly come to page 27. Roman 8, has a lot of got it, my lord. The Public Works Road Department, considering the views of the Director of Technical Education Assam and with the approval of the Honorable Chief Minister, while letter dated 1/9/22 has informed the APSC that Diploma in Civil Engineering and Planning is equivalent to Diploma in Civil Engineering, with request to consider the candidates who have acquired qualification of Diploma in Civil Engineering and Planning in recruitment process for the post of Junior Engineer Civil under Public Works Department. So it is the stand of the Public Works Department. In spite of that, my lord, APSC wants to take a different stand. When the, my lord, requisitioning department itself said in September 22, my lord. Just showing, my lord, unnecessary exuberance. So therefore, my humble submission is, my lord, an appropriate direction should go to the Public Service Commission, my lord, to redo the exercise and then find out, my lord, who is selected, who is not. Our cases were not considered on the ground that we do not have the appropriate qualification. That's not good. There are other 2-3 petitioners are there.
Same line, I think.
So,
Hello, my reply is very simple, Lordship. Only 3 to 4 line of submission, Lordship. Lordship, APSC being a selecting agency, Lordship, has nothing to do with the requirement of the government, Lordship. As Lordship has, my learned senior friend has already pointed out page 64, Lordship. Whereby,
Page 64.
64, Lordship. Whereby this educational qualification prescribed in the advertisement,
Civil engineering.
civil engineering, and it is as per the requisition of the government, Lordship. And this,
So if they have clarified later on,
Lordship,
then what to do?
I'm coming to that point, Lordship. And after issuance of this advertisement, Lordship, the application were invited, application received. We have proceeded the scrutinized, and also by the time this petition has been filed, the interview was also going on, Lordship. So at this stage, Lordship, on the basis of communication, subsequent communication, whether can APSC in the midst of that selection process can relax any norms and allow the equivalent qualified candidate in the interview, Lordship. This is the question posed to the APSC, Lordship, the legal point, Lordship. If APSC relax and allow that petitioners to participate in the interview process in the midst of that interview, then the similarly situated person which would have come if had there been a prescription in the advertisement has been deprived. This is the legal obstacle.
So you want a fresh?
No, Lordship. If
There's either two ways.
Lordship, there is
One
already
is
92 posts has been kept pending. Vacant, Lordship.
How many posts have been kept?
92, Lordship, as per
Two, only two.
92.
92.
And
How many posts were advertised?
307, Lordship.
So they have been filled up then. Basically,
No,
200
nobody has filled up, Lordship.
because the stay order is
Stay order is there. Because
So, but then how many posts were advertised?
307.
307.
Then why only 92 kept vacant?
Because petitioners are 91, Lordship.
Acha, and the others have been filled up.
Where no fill,
No,
we have
nobody, no
kept-
post.
no post
No
has been
post.
filled up.
Okay, so petitioners are 92.
Petitioner.
If lots until unless.
So let there be a fresh selection process.
If it, then if against the push has been advertised lordship,
Yes, you have to be re-advertised.
then entire process will be.
Now, what to do? Now you cannot bar persons who are eligible from participating in the selection process. That will be the most reasonable thing to do. Otherwise, now other persons will come that they have said this. They said civil engineering, that's why we did not participate. Then we are going to have another round of litigation.
This is a problem for APSC, not.
So the only way out is whatever has been done, let it be set at naught. Let a fresh advertisement be issued. And clarifying that civil engineering will also include so. And you take a selection. Though there was one aspect of the matter. Civil engineering is the major discipline, no doubt. But under that, there are a number of minor other disciplines. Then why can't the others also participate in that line?
In this case,
My lord, can I just comment?
Yes.
Here, my lord, if your lordship has seen that I have given the document, why this 3-year diploma was included? Because earlier in that 2-year course, my lord, they used to do only the draftsmanship. This architectural and civil engineering, that planning part was not included. Thereafter, it has been rechristened as civil engineering and planning. I have placed that, if your lordship has noticed that. Page number, I'll just show, my lord, from the rejoinder.
No, and the other issue is, civil engineering includes building, construction technology, civil and rural engineering.
Yes, no, lordship, if your lordship will kindly come to page 323 for a moment.
323.
Yes.
Yes.
Because in the state of Assam, my lord, only these 2 diploma are being imparted.
Acha.
Therefore, my lord, others will not come.
Okay, only these two. Okay, only
Kindly, yes, kindly see, my lord. In a new 3-year diploma course, civil engineering and planning has been introduced.
2004 it started.
The idea was, my lord, because you see, lordship, see second para. In new course, in addition to the course content of 3-year diploma, we have included topics on architectural design, architectural bylaw along with plan.
So the other courses are not there till now.
No, basically civil engineering. And
so if they were there, then they would also have to be included.
Yes.
Is a construction technology also, we have a batch of writ petition has come before this honorable court. And we are saying, it's not only it's a equivalent, what is in the AICT regulation, that has to be looked into it. Your lordship, all it is regulated by the AICT. So in AICT, if your lordship sees a notification, in that notification, civil engineering, there are categories. So we are saying civil engineering also a part of construction technology. Not only civil
even construction
to that extent, we are not in issue. We are not joining issues to what my learned friend is saying. Major core branch includes something. If those courses are, I'm sorry, my lord, I thought only these 2 branches are available. If it is there, they are also eligible. But there is a caveat, my lord. Only thing is, my lord, by now, because this litigation was filed early part of earlier year, 22. Now we are in 23. Now, if a fresh advertisement is issued, my lord, then, my lord, what will happen? Many more people, the zone will become very wide.
So
what I respectfully pray, my lord, they will make the fresh selection having regard to the earlier advertisement, where they will not, my lord, disqualify us on the ground that we are not civil engineers. Otherwise, what will happen, my lord? More people will come. Also, will kindly appreciate one aspect of the matter. If we go by the concept of year-wise panel, then people who was not eligible in 22, now who has become eligible, if a fresh advertisement issued, even if people of 22 will compete with 23.
Okay, that is one aspect.
Yes.
No, that is one aspect. No, but
we are not joining issues with my learned
no,
friend,
but then his coming in has complicated the matter a little bit.
No, there is
no complication.
No. There is one complication in a way. Now, okay, civil engineering and planning, okay, that is already, it has been taken care
all
of.
those earlier advertisement,
was in respect of civil engineering, even then construction technology, civil engineer planning was also inducted, they were appointed.
Correct. No.
Then, my
No,
lord,
no. Now, one thing is, you are building and you are representing
construction, yes,
building and construction technology.
construction and technology.
Acha,
Construction technology is there.
construction technology. is-
Construction technology.
No, which one are you representing? Which one? There's so
Yes.
many.
Item number 5400 2022. 83, item number
5400
of 2022.
of 22.
Yes.
5400 of 22. So what is your qualification?
Yes, my qualification you will kindly see. Nilupal Das. I will come to it. Kindly see, my lord. Page 31. My qualification. This is construction technology. Kindly see. Page 31.
Construction technology.
Yes, construction technology. This is a certificate by the State Council of Technical Education, Assam, for qualifying final diploma examiner 3-year diploma course held in so and so, so and so.
So construction technology is also one of the subjects
Of
of
is-
civil engineering.
Correct, right. And there are appointments. We have said there are earlier
So
appointments.
it is a core branch of civil engineering.
Yes, correct. That's
Now-
our case.
But the issue is now. Okay, so yes, so the thing is that in your advertisement, you did not, when you say civil engineering, it encompasses within it all those minor, I mean, those different diplomas.
That's it.
Now, how can you debar him also from participating?
This is the problem for us also, Lordship. In page 366, Lordship,
366,
360 of
which,
Lordship, 82, Lordship, item
Just a
number.
minute,
That's
just
Abhilasha
a-
Mohan's case, Lordship. Lordship, it is our new advertisement.
Huh?
It is Lordship, our new advertisement in
Yes,
of
yes,
2023, Lordship.
Yes.
Lordship, see, 6. Education
Civil
qualification
engineering and planning.
and planning, because I got requisition from the department that both civil engineering or planning can be considered. Accordingly, we have advertised. So we have nothing business with the candidate and the so the employer is the best just to choose the qualification of it. As Johor Ahmed Mohammed has also settled the law lordship. If department has clarified earlier lordship that both civil engineering and its equivalent, then all the petitioner would have come lordship in this selection process. If now lordship 92 posts has been kept vacant. So until and unless court has allowed them to participate, we being a constitutional body cannot relax lordship.
The thing is
This is my
that
question.
you want specific, that the department appears to want specific disciplines within the civil engineering,
Civil engineering.
major, whatever it's called.
We are not in dispute that civil engineering and construction technology is the equivalent. Equivalent is one part.
So
And the-
civil engineering and planning is one of the disciplines
Yes.
within
equivalent.
civil engineering. Civil engineering itself is also a
Equivalent
discipline
to-
within civil
These
engineering.
are all equivalent. We have not on dispute.
Ah.
lordship.
They
Allied
are,
lordship-
they are allied branches having maybe different curriculums
Right.
or the little bit here and there.
Syllabus is almost same. That's a syllabus they have also.
But then supposing they say that, no, we want only these things. We don't want all the disciplines. We want only a few specific disciplines. Can't they limit themselves? Can't the
Then
government
if
limit
it is-
the field that they
Well,
want
if
to?
it is that be the case, then only the who qualified, who was in the field of civil engineering, only they will get the appointments, none others. So we have taken a course knowing fully the civil engineering nomenclature of others also, like civil engineering planning, construction technology is also a part of civil engineering. Otherwise, my lord, why? There is an appointment which is given earlier.
Why, you see, one thing is that with regard to civil engineering and planning, government has already taken a decision.
Yes, 2021.
Yes. Now, even in that affidavit.
Yes.
On the basis of the other, the AICT and that directorate.
But
The
problem is
clarifications.
it was during the interview process, Lordship.
Whatever it is, now the issue is, what about this, actually, you're not the government, who's the government?
Yes. You will take a call in this.
Yes, Mr. Nair.
Our basic issue is that this is an advertisement of 2019. And clarification came in the year 2022.
Whatever, clarification, at least it has come later.
Yeah.
At least it's better late than never.
One discipline is concerned, Lordship, government has given its, view.
Correct, correct.
But other departments are concerned, government has not taken any decision.
So why haven't you
So
taken?
this is one aspect, Lordship. Lordship, so for example, Lordship will take the example of health science, diploma in ophthalmology, diploma in child care, diploma in so many diplomas.
Correct, correct. Many disciplines are there.
Core branch is the health science. Similarly, Lordship, civil engineering is the core subject, Lordship. Diploma in transport technology, they construct the airport runways, Lordship. Diploma in planning, Lordship. So many branches are there.
Correct.
Syllabus is not same in any of this.
Correct, correct.
Lordship, one diploma in civil engineering was already there. The petitioners did not get upon admission in the civil engineering section branch, Lordship. That is why they choose for other courses. That is one. Now, Lordship, legal issues are involved there, Lordship. Now, while recruiting to the post of junior engineer, we follow a particular rule. In this case, Lordship, we follow the Assam Subordinate Engineer Irrigation Department Service Rule 1978. Dear Lordship, for the post of subordinate engineer, at that point of time it was subordinate engineer, now it is junior engineer. It's clearly mentioned as diploma in civil engineering.
Rule was made when?
Lordship.
Rule was made when? When was the rule made?
78, Lordship.
78.
We are following.
So rule was made in 78. That time, what diploma courses were being provided?
Civil engineering.
That was the only civil engineering.
No, I'm not saying that, Lordship. Right? At what point of time rule was prepared, Lordship? That is not pertinent, Lordship. Pertinent question is whether that rule was subsequently amended or not. Till now, that has not been amended. That is one. As per rule, Lordship, requirement is diploma in civil engineering. That is settled, Lordship. Secondly, Lordship, one advertisement has been issued, rightly or wrongly. Both the qualification has been specifically mentioned, diploma in civil engineering, Lordship.
Okay, now one thing, in this case, this case relates back to the earlier advertisement, the earliest advertisement. So any decision taken by the government would relate back to the advertisement.
Lordship,
Now-
that so far as that affidavit is
Yes,
concerned,
this affidavit.
yes, so far as one
Now,
branch is concerned.
so this one branch now has been made equivalent to this civil
The
engineering,
AICT has not said that syllabus of both the courses are similar.
whatever.
AICT
But the government has taken a
On
decision.
the basis of.
Now, are
The
you?
Lordship will consider the fact, diploma in Ayurveda, diploma in homeopathy, same equivalent, but the branches are different. So equivalency and similarity are the different issues, Lordship.
But
It
then
may
it has
be equivalent.
also, but remember this, to consider the candidates.
I'm not denying that, Lordship.
So that,
far as
that
issue is
so that
concerned,
issue
Lordship, I'm not.
with regard
But
to,
Lordship will, at the same time, Lordship will also consider whether on the basis of the rule, on the basis of the advertisement, this is the stand of the government, Lordship, that is there, whether legal issue,
but what about this construction technology? You have not made any,
No.
you have not taken a decision.
Neither they file any affidavit.
But
in this
you
case.
have to take a decision.
Lordship, this decision was there, then that is why we have filed an affidavit. Lordship.
No, but have you filed an affidavit in this
not
writ petition?
No, they were silent on
Now that is the problem. Now you see, I can pass an order, but then it will be an incomplete order. Because the issue now is, supposing we direct that a fresh advertisement be issued.
Fresh advertisement.
But then whether that would include construction technology, a decision has to be
That
taken.
is not sure.
That is what you have got to file a reply to that.
My only submission would be, Lordship will decide this case on the basis of the rule and on the basis of the.
We will do that, provided that you also give a reply to the questions put forth by them.
No, so
It's
far
your
as
duty.
this affidavit is concerned, construction technology has not yet been given the note.
No, you see, that is all right. But with regard to his writ petition, you have a duty to answer it.
Lordship.
Then,
Lordship, my feeling was that one affidavit will cover all the cases.
No, that cannot be.
Because in one case we have accepted, that is why that has been mentioned. In other cases, it doesn't, no mention is there, Lordship.
you have not made
My
a.
lineage friend can't say that one affidavit will cover my case.
You
That
you
how
have
can
not
it cover my
mentioned,
case?
you have not taken any categorical stand with regard to construction technology. If you had taken, then we could have said yes.
Lordship, I will file then, Lordship.
Just make one categorical, so that at least we can decide the matter in full, otherwise it will be in part. If I allow partly, say, Mr. Ken Chaudhary's petitions, saying that he has to be considered, then he will say that, wait a minute, let my issue be settled first.
Lordship.
We cannot do things in part.
Lordship will take up all the matters together, Lordship. Let me file one affidavit.
To point out, the page 32, Lordship has put, that affidavit.
32.
32, Lordship.
32 of this. Yes, page 32.
That's letter, Lordship. Of WPC, Lordship, 2064. Lordship, got it?
Yes.
Lordship, the subject, Lordship, this letter was issued in the application of 5400, Dilute Koldas and 32 others.
Just
by
a minute.
Lanet Senior Friend.
540.
And those each petitioners.
Acha, it has been given a 5400.
5400. In 5400 relating to the diploma in civil engineering and construction technology. But by this letter, though it was issued in terms of subject 5400, but in the diploma in civil engineering and training is equivalent to diploma in civil engineering. In a writ petition, where petitioners are praying for diploma in civil engineering and construction technology, but this letter is issued in respect of diploma.
Somebody, something else. Correct. So yes, Mr. Please clarify this page 32. You see, this page 32, if you look at the subject, it deals with WPC 5400/2022. That is Mr. Dighanta Das's writ petition. But it does not make a mention of construction technology. It makes a mention of Mr. Ken Chaudhary's case.
Suppose, my lord, tomorrow they come with an affidavit saying that it is not equivalent, nomenclature is different. Then I have to argue my case on the basis of the law.
Yes, you have to argue.
What is the effect of the rules? How is All India Council? I am prepared for that. I know, my lord, my case. Because
you see, we can hear you right now also, no problem. But only thing prior to that is that we want to know the stand of the government.
That's why I want to say, my lord, I didn't.
Stand of the government is not clear by this letter.
In my case, it is not clear. They have not spoken anything about my case. Whatever had been said in Mr. Chaudhary's case has been said. Not in my case. No affidavit has been filed in my case.
Okay, right.
Since the lordship is not concluding the matter, I give a brief reply to what public service officer.
Yes. What regarding what?
Now I'm not dare saying that it is based on the requisition, they have made the selection.
Correct.
But in their affidavit, lordship has seen, they have set up committees to find out whether these two are same and different. And my learned friend, Mr. Nayak, my lord, has also made a submission regarding equivalence and similarity. Neither is appropriate. Here, question is whether a major core branch includes the allied branches or appropriate branches. That is the case. And here the expert is All India Council for Technical Education. All of India Council for Technical Education by notification dated 28/4/2017 has already clarified. But if they had any doubt, they should have referred to AICT instead of instituting the committee of ACS officers. And secondly, my lord, the director of technical education Assam has already clarified.
With regard to your case,
Yes, in my case.
but we want a clarification.
No,
with regard-
in his case, but if you go by AICT, which in a reply we have like AICT, and my lord, kindly see Rule 8 of the Assam Technical Education rules, which they adopt the All India Council of Technical Education. So in this, I have filed a reply stating this is 2017 All India Council of Technical Education. Civil engineering, these are the branches which include construction technology, others also. So how, and there is an addendum to it. I will show it, my lord. If they come also, they say, let us say they say it is not similar. It is not equivalent. What happens to me then?
Okay, supposing they say they want candidates only from civil engineering, having the and within the discipline of civil engineering, then what? Then what?
No, then, my lord, it is not in accordance with the All India's Council of Education, Technical Education, and the state doesn't. Also, basis of what is the qualification? It is laid down by All India Council of Technical Education, which is adopted by the state under Rule 8. So how they have to give an answer to it, my lord.
When can you give this instruction?
So far as my learned seniors case is concerned, I will file my affidavit within 1 week.
Affidavit.
Let me file yours.
Affidavit is required. You take your instruction.
There is an order to file affidavit.
Oh, there's an order.
There is an order.
In which case?
55403.
My lord,
Huh?
delayed, let my learned friend have the instruction next week.
Oh, next week, but they have to come. Otherwise, they will come and say that this is not applicable without any record.
If their lordship decide my case, then what is about this case? So therefore it's better.
Yes,
lordship,
we have
take
got-
all
we-
collective.
We have got to dispose of collectively. We cannot do it in part.
No, correct. Only thing is, my lord, if my learned friend gets the instruction early, sometimes in the later part of next week.
Okay, anyway, let us
Next Thursday, my lord, if it is possible.
let us dictate a little bit.
Yeah.
Now this item 80, whose case is this? Item 80.
Well, 80 is the filed by the person who got selected.
Oh, it is by
They
the
are
person.
seeking a direction for appointment.
Acha, who is representing 80?
Huh?
Serial number 80.
Or they have appeared in the interview. So they want vacation of the order basically.
Section 80. Okay, who is representing them? No one.
Or Mr. Bongik Bora, BP Bora.
BP Bora.
They want that result should be declared by them.
Okay, then 5337. Yes, you're Mr.
Same with us.
MP Sharma.
Same with us.
Same. Okay, Mr. MP Sharma, then
File 81, my lord.
81.
File an increment application, my lord. We have appeared in the interview, my lord. Already we have appeared, my lord. We are the selected candidates, my lord.
What is your name?
F. Khan, my lord.
F. Khan. And then in 82, Mr. K. Chaudhary is there. And again, Mr. F. Khan is again interviewed. Huh? Yeah, okay.
All the items.
Okay, then 83,
I appeared.
Mr. Didas. F. Khan is again there.
My lord.
Then 84,
And one more time.
M. Burma. You're the same. You're what? What are you? Planning.
Same with
CP.
us.
Then F. Khan is again there. Then 85, AV Singh. AV Singh, WR Medi.
No. We are only 85 more than 90.
Just give me this case, 85. 85. Serial number 85.
Oh. Everything.
DJ Das.
Construction.
Mr. D Das, Learned Senior Counsel. No. Sorry, this is the thing.
WR Medi.
WR. This construction technology.
Yes, mine is also, I don't know, somebody has appeared. I appeared in item number 83.
No, 85 is again construction technology. Again, similar to you.
Yes, similar.
I just want to know the difference. Then F Khan is again there. Then you MP Sharma is. You are what? CP? CP. And then F Khan. Okay. Right.
The order is at 31/8/23
For what?
for filing affidavit.
Oh, 31/8/23.
31.
Oh, in which rate petition?
It's all writ petition. But lead petition is 4064.
More affidavit.
No, there's nothing here. It says order dated?
31/8/23.
Okay. Okay, right. Heard Mr. Just give me item 80 also. Item 80 is which one? Item 80 2064. 2064. What is the prayer out here? Okay, this is for declaring the results.
Basically, three sets of petitions.
Yes, 3 sets. Okay, right. Heard Mr. K. Chaudhary, Learned Senior Counsel for the petitioners in WPC number 5355/2022. That's all, only one case. And Mr. Diganta Das, Learned Senior Counsel for petitioners in WPC number 5400/2022. That's all.
Yes.
One. I've also heard Mr. MP Sharma, Learned Counsel for the petitioners in WPC 5337/2022. And for the petitioners in WPC 2994/2023. Mr. M. Burman appears for the petitioners in WPC 5495/2022. While, no one appears for the petitioners in for the petitions in WPC 5840/2022 and for the petitioners in WPC 2064/2023. Mr. F. Khan appears for the applicants in WPC in IA civil number 2866/2023, 2853/2023, 2872/2023, 3078/2023, 2876/2023, and 3013/2023. Next part. The issue pertains to the non-consideration of the petitioner's application for selection to the post of junior engineers, civil, in the PWD under the government of Assam, pursuant to the advertisement number 6 of 2019, dated 19/11/19, and another advertisement. No, that's all. That's all. So, Mr. Das, you are challenging only one advertisement, correct?
This is the advertisement.
That's the only one.
Yes.
You're not challenging the subsequent.
I'm sorry.
You're not challenging the subsequent advertisement.
This we are challenging.
Only this. Okay, full stop. Next. The case of the petitioners in all the writ petitions mentioned above, except for the petitioners in W 2064/2023, is that the petitioners are having diploma in civil engineering and planning, while some other petitioners are having diplomas in construction technology. The advertisement number 6 of 2019 required the candidates for appointments to be to require the candidates to have passed 3 years diploma course in civil engineering from an institution recognized by the government. Though the petitioners in all the writ petitions except for WPC 2064/2023 had the required diploma course in CEP and construction technology, which were branches of the branches/disciplines under the major/core branch of civil engineering, the petitioners were not allowed to participate in the selection process for recruitment to the post of JE civil under the PWD. On the ground that the advertisement had only made a mention of, inverted commas, civil engineering as an educational qualification, as an eligible as an educational qualification for the purpose of selection. Full stop. And no, and had not mentioned, and that it had not mentioned, and that it had not made a mention of CEP or construction technology. Full stop. The petitioners in WPC number 2064/2023, on the other hand, had taken part in the selection process for recruitment to the post of JE Civil PWD pursuant to the advertisement number 06/2019. And their prayer is to direct the state respondents to publish the result of the selection process, in as much as they had taken part in the interview. Full stop. The no, Mr. The IAs in full, you're right, the IAs are also have been filed. IAs have been filed by candidates who have taken part in the selection process and who want the publication of the results of the selection process. Next para. After taking this court through the various decisions of the AICT and but where is that directorate of
Yes. One second. P28.
AICT and
Yes, P27.
the Directorate of Technical Education, Assam.
P26 and P27.
Which is to the effect that diploma in civil engineering and planning may be considered as equivalent to civil engineering, as diploma in CEP belongs to the core/major discipline of civil engineering, the state government in their affidavit in opposition filed on behalf of filed on 7/10/2023 in WPC 2064/2023 has stated in para 3 bracket Roman 8 small that the Public Work Roads Department, considering the views of the Director of Technical Education, Assam, and with due approval of the Honorable Chief Minister Assam, vide letter number RBEB 79/2022/313 dated 1/9/2022, has informed the APSC that diploma in civil engineering and planning is equivalent to diploma in civil engineering, comma, with the request to consider the candidates who have acquired the qualification of diploma in CEP in the recruitment process for the post of junior engineer bracket civil under the SMPW. As such, it prima facie appears that the petitioners who have acquired the qualification of diploma in CAP would have to be considered in the recruitment process for the post of JE Civil under the SMPWD in pursuance to the impugned advertisement. Is it impugned? Full stop. However, no decision appears to have been taken by the state respondents with regard to the petitioners who have acquired diploma in construction technology, which appears to be a part of the major / core branch of civil engineering. In terms of, where is that?
28,470.
No, which page?
Page number 316, my lord. It starts at 316 and operative portion is at 315.
In terms of the AICTE notification dated 28/4/2017, bracket page 316-317 in WPC number 5355 of 2023.
We have also got it, 54000, that.
It doesn't make, that doesn't.
212, no, just I am telling you,
Okay.
Lordship, we have also brought notice to the court.
No, actually, I have heard him through.
I know it.
That's why I know what is pattern. Next para. No, continue. Full stop. On the other hand, page 32 of the no, on the other hand, the affidavit of position. No, on the other hand, annexure Roman 2 of the affidavit of position filed by the respondent number 1 in WPC number 2064/2023 is a letter dated 1/9/2022 issued by the Deputy Secretary to the Government of Assam, ESTT B branch, PWRD, Dispur, which is to the effect that a clarification regarding the qualification of diploma in civil engineering and planning being equivalent to diploma in civil engineering was sought for from the Director Technical Education. The said letter, however, refers to the subject pertaining to WPC number 5400/2022, wherein the petitioner's qualifications therein are with respect to diploma in construction technology and not diploma in CEP. So consequently, Mr. P. Nayak, the learned counsel for the PWD, and what about the Director of Technical Education?
Higher education.
Technical, yes, technical education. You obtain instructions. And, huh? Huh? Where is he? And Mr. D. Upamanu, learned counsel for the high technical education. Standing counsel for the higher education. Huh? Higher education. Higher technical education department shall obtain instructions with regard to whether the diploma in civil engineering and diploma in civil engineering, no, diploma in civil, diploma in construction technology is equivalent to diploma in civil engineering, and whether holders of diploma in construction technology can also be considered in terms of, pursuant to the advertisement number 06/2019, dated 19/11/2019. List the matter on. When?
Next Thursday.
I am ready.
Yes, my lord.
List the matter on Thursday. You please get the information from, you tell the other council, Mr. D. Upamanu.
For further hearing, man.
Yes,
Further
pardon.
hearing. Further hearing. You have heard this matter. Can you further
I have to basically hear you, depending upon their thing.
Yes,
If
of course.
if they have clarified, then maybe I don't need to hear you also. But if they are
If
not
they-
in your favor, then
No,
I'll
if
have
they
to hear you.
clarify, if they say it's not equivalent, I have to argue.
Correct,
That they
correct.
are wrong. It is not, it's a great country. Yes, that's why.
My lord, the engagement applications may be allowed, my lord.
No, no, let it be kept in. On the
My lord, we have to file, my lord, our affidavit, my lord. I think last date, my lord, they were given an
Will
opportunity.
you file it within 3 days?
Yes, yes, my.
There's hardly anything
Because
else.
my lord, we are saying that.
It's okay, let them come, because let them, it may be delayed a little bit, but at least everyone will be heard.
Yes, my lord. I think it's three, my lord.
Item 18.
Yeah, earlier order will not.
Okay, item 80. In item 80, you put Mr.
Lordship said none appears for census.
Mr. BP Bora appears for the. Okay, then you write in the IAs, huh? Good stuff. The, right, next para you write. The IAs, no, Mr. F. Khan submits that the petitioners, that the applicants who have taken part in the selection process by appearing in the interview in terms of the advertisement number 06/2019, dated 19/11/2019, should be heard inasmuch as the applicants having fulfilled all the criteria for consideration for recruitment to the said post, comma, the only requirement of the state government is to, no, the only requirement of the selection committee / bracket APSC is to publish the result. Accordingly, the applicants may be implemented as respondents. Then who will file the amended writ petition and all?
My lord,
I think my lord, they can be added as response.
yes, my lord.
Okay, and they will implement as responses. The applications are allowed? No, no, then before that you write Mr. K. Chaudhary, learned senior counsel, and Mr. D. Das. Yes, and all the others, all the others submit that they do not have any objection to the application being allowed. Accordingly, the applications are allowed and disposed of. Okay, before that you write the applicant shall submit what?
My lord, in item number 81, we may be impeded as respondent number 7, 8, 9, 10 up to 16, my lord.
I cannot mention all that. It takes so much. Okay, you write. Insert you take the prayer.
List, they can give it the list.
Yeah, you give the list. Sir.
I'll give.
There are, my case also is there.
Yes, yes.
My choice, you can give the list.
Sir, who is going to give the amended cause list to the registry?
No, registry will, my lord.
They will correct. Yes.
No, but because now it has to be uploaded in the
Yes.
system. everything will change.
But understand to take the problem, pardon my.
He'll have to. They're,
My lord, we'll do it, my
huh? Afusab accordingly.
memo of parties, my.
Not only memo of parties, I think, okay, memo of parties.
At least the cost saving portion.
I do not know how it's going to be done.
No, Lordship, you will file an application for correction of the cost side.
My lord, we'll do it.
No,
my
no,
lord.
they have to do it.
Yes, sir.
Registry cannot do it.
You will have to
They
file
will
an
provide
application.
in the email form, my lord.
My lord, earlier occasions we have done in some.
Okay,
cases, we'll
okay.
do it.
The applicant shall submit
The amended cost.
the amended cost title to all the writ petitions in which the applicants have been implemented as
Yes.
respondents
I'll take the
within
3 days, my lord.
3 days.
My lord, they may be directed to give me the copies, my lord, of the pleadings and all, my.
Am I appointed?
Sir, Lolo, my lord. I'll just request that provide, yes, yes. All the copies, my lord.
Okay.
Whatever.
The IAs are accordingly disposed of.
Quickly up. Sir, fine.
Huh? You keep it here. You staple it and keep it. It's in.
Lordship, in this case also, the Upamanyu is appearing for a higher education, Lordship, and affidavit has been filed, Lordship. Otherwise, whether we take him any other day, Lordship. He has some difficulties, he has to leave the court.
He has to leave the court.
Or what I got information, Lordship. That's why.
Can it be around the end of this month, madam, around 30th of November, madam?
On?
30th of November, end of this month.
We can try.
Yes, you can.
Right. Mr.
S. Bhuya,
S. Bhuya submits that Mr. D. Upamanyu, the learned counsel for the
higher education, Lordship.
higher education department, is having some personal difficulty and had to leave the court. To stop. Prayers allowed? No, he accordingly submits that the matter may be adjourned. To stop. Mr.
S. Count.
S. Counsel for the petitioner, please that the matter may be listed on 30th of November. List the matter on 30th November.
In this case, no affidavit has been filed, madam, though notice was issued on 21/6, madam. The matter pertains to, madam, the overall amount.
Just call the people.
Overall amount, madam, the recovered from the, madam, the death benefit, madam. To the, madam, wife of the deceased employee, madam. It is better than, madam, the Rofik Masi, madam. Better than, madam, the Rofik Masi, madam.
2 minutes.
Madam.
Yes, what is this?
Method quotation the excess amount overpay allowance deducted from the death benefit of the deceased employee But it
What is
Rofik Masi case
what is
after-
he? What is he? Grade 4, grade 3?
No, grade 3, my lord, accountant.
Huh?
Accountant, grade 3, my lord.
Why was there overpay? On what ground? Why was there overpay?
Stating after submitting the pension proposal, that come to knowledge that the husband of the petitioner received excess 100 basic pay. In
Since when?
In the year 1983.
This is 83.
83, And it can-
Yes. Where is the document?
document, kindly see sanction letter, page 39. It is issued by the Office of the Accountant General to the Treasury Officer, wherein directed in below portion other government dues 8,62,270 overpayment of pay and allowance. Total recoveries 8,62,276, and subsequently it was recovered from the DCSG amount.
But how do we know it's due to that false, due to the wrong fixation of pay? How do we know that? Where does it say that it is due to wrong fixation of pay?
I have no document, but subsequent overall statement was kindly see page 17.
I think we have page 17.
Page 17, my lord. Annex 3, it is the statement.
Overall, we have to know the reason. Yes.
My lord, thanks for the PNID department, my lord. We have received some instruction as per the instruction, my lord, from 1983 till 27/4/2020. The petitioner received some an additional amount of 100 rupees.
So that was a mistake committed by whom?
My lord.
No, my lord.
So is in your let us see your parawise comment. Was there any fault or any on the part of the petitioner? Was there any forgery or something, misrepresentation on the part of the
My lord,
petitioner?
that instruction is not there.
There is not.
My lord, the BDO was requested to furnish the corrective service book.
Who was supposed to furnish?
The BDO.
BDO.
The commissioner requested the BDO to submit the corrective pension service book, and after that was furnished, we have forwarded it to the Accountant General Office, and they have deducted the amount. My lord.
Look, whatever family pension is to be paid, it should be given, you can correct it, you can give the correct family pension as per the entitlement, correct entitlement.
Recovery.
However, recovery cannot be allowed, not in this matter. Only thing I want to know whether the post of accountant is a grade 3 post or not.
That instruction.
As per my knowledge,
Your knowledge is not enough. We want them to tell us that. So what you can do during the lunch hour, you can call up your office, ask them whether the grade 3 post, whether the post of accountant is a grade 3 post.
My lord, as per my knowledge, my lord, it is a grade 3 post.
It is okay. Then it's okay. If I'll say that both of you agree that a grade 3 post. End of the matter. What are the judgments besides Rafik Mati? There's another one. I think some Verma, some Shyam Babu Verma, I think.
Sam Babu Verma.
Shyam Babu Verma. When did your husband die?
Like, मला 27/4/2020.
27/4/2020. And this they've cut from the DCRG.
DCRC, my lord.
He died in harness.
My lord.
Okay, right. Heard Mr. K.R. Patgiri, learned counsel for the petitioner. Also heard Mr.
U Sharma on behalf of Mr. K. Kaur.
Mr. U. Sharma on behalf of Mr.
K. Kaur, senior
K.
standing
Kaur, learned counsel appearing on behalf of
PNID department.
PNRD department. Anybody else? Mr.
A. Chakraborty.
A. Chakrabarti appears for respondent number 2, while Mr. A.K. Medi appears on behalf of Mr. S.K. Medi, learned counsel for the respondent number 5. Good, sir. The matter pertains to the prayer of the petitioner herein is to set aside the sanction letter dated 16/2/2023 issued by the office of the respondent number 5, insofar as it has directed recovery of rupees 8,62,276 from the DCRG payable to the petitioner, due to payable to the petitioner, full stop. Further, a prayer has been made to direct the respondents number 5 to 7 to repay the amount deducted. Full stop. Next para. The petitioner's case in brief is that her husband, Paban Gayari, Pabangayary, who was serving as an accountant cum storekeeper at Raha Development Block in Nagaon district under the PNRD department Assam, died in harness on 27/4/2020. Full stop. The next para. The petitioner submitted pension papers to the concerned authority with a request to sanction compassionate family pension as well as other death benefits, as well as other service benefits to the petitioner. The respondent number 6 forwarded the petitioner's application for compassionate family pension to the respondent number 5, to the respondent number 4, who in turn forwarded the same to the respondent number 5. The respondent number 5 thereafter issued the impugned letter dated 16/2/2023 to the respondent number 7.
My lord, may I submit, my lord? My lord, this letter has been issued by Accountant General's office. Not by the respondent number 5.
Letter dated 16/2/2023 has been issued by the.
My lord, apology, my lord. Listen.
Correct, no?
Correct, my lord, correct.
What have I said? Sanctioning death cum retirement gratuity bracket DCRG amounting to rupees 99,77,988 payable to the petitioner. Full stop. However, the impugned letter dated 16/2/2023 also issued a direction to the respondent number 7 to recover an amount of rupees 8,62,276 as dues. As what kind of dues?
Overpayment of,
As,
overpayment.
wait, let me see the letter.
my lord, letter A39, my lord.
39.
A5.
As dues, as dues, comma, due to overpayment of pay and allowances to the petitioner. Listen. The petitioner has prayed for setting aside the impugned letter dated 16/2/23 and directed that the recovered amount should be given to the petitioner, should be given back to the petitioner inasmuch as the petitioner's husband being a grade class 3 employee, comma, no overpay of pay and allowances could be recovered from him, comma, in terms of the judgment of the apex court in the case of State of Punjab and others versus Rafiq Masi, bracket whitewasher, right close, and others, reported in 2015, 4 SCC 334, and in the case of Shyam Babu Verma and others versus Union of India and others, reported in 1994, 2 SCC 521. Next para. Mr. What's your name?
U Sharma.
Mr. U Sharma, learned counsel appearing for the PNRD department, submits that he has received instructions from the department and as per the instructions, comma, it is and as per the instructions, comma, on scrutinizing the family pension proposal of the petitioner, comma, it was found that the petitioner's husband had been given the basic pay of rupees 542 instead of 482. With effect from 1/1/1983. This is not 100, Mr. Counsel.
My lord.
This will be only 60.
60.
My lord.
In view of the above wrong fixation of pay of the petitioner's husband, comma, the total overdrawn payment of pay and allowances amounting to rupees 9,77,988. No.
No, my lord.
8,62,276 had to be recovered. He accordingly submits that the that the recovery of the money which was mistakenly paid to the petitioner's husband should not be recovered.
That instruction is not because that the commissioner had directed requested the AG to recover the amount.
No, but it has been recovered.
Recovered already.
Actually, you're for the PNRD. It is, but recovery has been made by the
Accountant general sanction letter was issued, my lord.
That is the.
Anyway, that is their submission. How does it matter? You are saying that since that was that was what was found by the
We have only scrutinized the paper and we have noticed that some overdraw amount has been.
correct, correct.
But we have not requested the AG's office to recover that amount. We have
Anyway,
only
doesn't
submitted-
matter, doesn't matter. Basically, you are supporting you see, you have to support your government. If they have done it, you cannot say that, yes, what they have done is completely illegal and wrong. Can you say that? You want me to say that? I can
No,
say
I
that.
don't.
Then you are supporting them, that what they have done is nothing wrong. They have taken back what they mistakenly gave him. That's all. Yes, who's for the accountant general? And you're for the accountant general. What is your submission?
Recovery is on the basis of the departmental data.
Huh?
On the basis of the departmental data.
Because of the wrong fixation of pay. And what about you for the treasury officer?
No.
Okay. Next para. Mr. Huh? KK Medi, learned counsel for the accountant general's office, submits that there is no infirmity with the decision of the accountant general to order the recovery of the overdrawn pay and allowances by the petitioner's husband, in as much as the petitioner cannot be allowed to enjoy the fruits of a mistake committed by the PNRD department, committed by the government in mistakenly giving the petitioner the basic pay beyond his entitlement from the year from 1/1/1983. That's correct. Full stop. I have heard the learned counsels for the parties. Full stop. As can be seen from the parawise instructions given to the PNRD department council, which has been submitted before this court, and and the submission made by the counsel for the accountant general's office, the petitioner's husband had been given his pay and allowances due to a mistake committed by the government due to wrong fixation of pay made in the year 1/1/1983. There is nothing in the parawise comments or in there's nothing in the parawise comments to show that there was any fraud or misrepresentation made on the part of the petitioner's husband to have during the making of the wrong fixation of pay by the government. Next para. In the case of Shyam Babu Verma and others, Supra, which para? Oh, meeting. Oh, okay, at 2. I've got a meeting at 1:50.
Offline.
Which para?
Paragraph 11, my lord. Last portion. Above the colon, it shall only be just and proper not to recover any excess amount which has already been paid to them. Accordingly, we direct that no steps should be taken to recover or to adjust any excess amount paid to the petitioner due to
In the case of Shyam Babu Verma Supra, the Supreme Court had held that since the petitioners therein had received the higher scale of pay due to no fault of theirs. Since 1973, it would not be just and proper to recover any excess amount paid to the petitioners due to the fault of the respondents. In the case of Rafiq Masih Supra, the Supreme Court has held that
Paragraph 18.
recovery from employees belonging to class 3 and class 4 employees, service employees, would be impermissible in law. Where payments have mistakenly been made by their employer in excess of their entitlement. And when the excess payment has been made for a period in excess of 5 years, before the order of recovery is issued. Next para. In the present case, there is nothing to show that the wrong fixation of pay made in the year 1993 had been made. 1983 had been made due to any fraud or misrepresentation on the part of the petitioner's husband. As the wrong fixation of pay had been made by the state respondents erroneously, it would now not be. It would not be permissible to now recover the excess payment made after the death of the government servant in the year 2020. In that view of the matter, the recovery made on the excess pay and allowances made to the petitioner's husband by recovering the same from the DCRG amount payable to the petitioner. Cannot be allowed. So accordingly, the impugned letter dated 16/2/2023, insofar as it allows a recovery of rupees 86,276 as overpay of pay and allowances to the petitioner's husband, is hereby set aside. The respondents are directed to reimburse the petitioner with the amount of rupees 86,276 immediately. And positively within a period of 1 month from the date of receipt of a copy of this order. The writ petitions accordingly allowed and disposed of. All right. 59 and 90. 59 and 90. Yes.
Lordship, due to some personal urgency, Lordship, my senior had to leave, Lordship. Kindly, this matter may be.
Which item is this?
Adjourned for the Lordship.
89.
89 and 90.
Pertaining to 89 and 90, Your Lordship, we have received partial instruction, Your Lordship.
Yeah.
So, Your Lordship, kindly grant us 1 week time, Your
Has
Lordship.
has the departmental proceedings been initiated?
Yes, Your
It
Lordship,
has
that
started.
has initiated. But the order has reviewed or not, that instruction we need to take, Your Lordship.
Okay, right. So you want adjournment also, madam?
Yes.
Why?
Lordship, my senior had to leave, Lordship, some urgency.
Okay. Miss, what is your name?
P. Das, Lordship.
P. Das, appearing on behalf of
Mr. K. Das.
Mr.
K. Borwas, Lordship.
K. Barwa, learned counsel for the petitioner. petitioners and Miss,
Pidas,
oh, Peters, okay.
on
Uh,
behalf of P Nayak.
Appearing on behalf of Mr. P. Nayak,
Yes,
learned counsel for the
BTC,
BTC.
respondent 2 and 3.
Pray for adjournment. Same is allowed. List the matter after a week. In the meantime, the counsel for the BTC shall obtain instructions as to whether a review of the suspension order, a review for extension of the suspension order had been made by the state respondents.
Deeply obliged.
99.
Clear, please, Your Lordship. This matter is relating to transfer and posting of Gaon Panchayat secretary. The issue is whether the government can is empowered under law to delegate the power of the commissioner to the deputy commissioner.
Whether the deputy commissioner,
Power of the commissioner, Lordship, that is director of Panchayat and Rural Development, Lordship. Now director has been re-designated as commissioner. So whether the power of the commissioner or the director, as the case may be, Lordship, can be delegated to the deputy commissioner for making a transfer
by the director, by the commissioner, whatever.
by the Lordship government.
Why not?
That is, Lordship, if your Lordship kindly come to page 24, this is the MP note.
Are you ready? Are you ready?
Ready.
No, they have filed affidavit. Lordship. Page 24 is the MP notification, which is under challenge.
Yes.
This for administrative convenience and in the interest of public service, the deputy commissioner in general area district are hereby authorized to make transfer and posting of block development officer, engineers, Gaon Panchayat secretaries. We are concerned with Gaon Panchayat secretary, and all other regular officers and staff, including all contractual employees of Panchayat and Rural Development Department within their jurisdiction. My lord, in view of this notification, the page 25 order has been issued, that is transferring the petitioner from one place to another place. Page 25.
Yes.
Well, here, the name of the petitioner, Lordship, serial number 16, 19, 33, 36, 45, 46, 49. Well, two petitioners out of this Lordship, 9 petitioners have already been protected by the interim order because they are in the Bharsa Panchayat. And all other Lordship, there is no interim order in favor of the petitioner. Now, your Lordship, kindly have a look to the provision of Assam Panchayat Act, Lordship. Basically, Lordship, law point is involved in this case. Section 30.
Delegation of powers is made by whom in the state?
By the state government.
So if it's the government, Secretary to Government of Assam, PNRD, that is the government.
Yes.
Then
government has delegated the power of the Lordship Director of Panchayat and Rural Development. And so far the provision is concerned, the government of its own power can be transferred to the gazetted official, Lordship. That I will show you, Lordship. And power of the deputy commissioner and the subdivisional officer can also be delegated to any other. But so far the commissioner or the director of Panchayat or Rural Development, Lordship, that power cannot be delegated. That is silent in the provision. Secretaries are provincialized Panchayat employees.
we don't. You didn't give the list of books.
But only the 2-3 provision.
Unfortunately, we don't have it.
Yet.
Well, I have my act. I don't have it. Well, as far as the case of the petitioner is concerned, Gaon Panchayat secretaries, they are provincialized employees. So as far as provincialized employees are concerned, section 30 of the Act,
that is
section 30 of the Assam Panchayat Act.
Yes.
Section 30 of the Assam Panchayat states that there shall be a secretary and other staff as may be prescribed by government in every Gaon Panchayat, who shall be appointed as provided in section 141 and or deputed by government from time to time. In respect of the provincialized employees, the Director of Panchayat and Rural Development shall be the appointing authority. So now this Office of Director of Panchayat and Rural Development has been redesignated as Commissioner. So as far as provincialized employees are concerned, my lord, the Commissioner is the appointing authority. Now I would like to draw my lord's attention to FR 15 of the FRSR.
Give back this.
Page 28, my lord, of the FRSR. Page 28, FR 15.
Yes.
FR 15 states that the state government may transfer a government servant from one post to another, provided that except these are 1, 2, whatever. So, my lord, the state government has the power, is empowered to transfer such government servants from one post to another. So now the government, that is the Secretary PNRD in this case, has invoked section 138 of the PNR of the Panchayat Act 1994, my lord. 138.
138.
138, my lord.
That is page?
Yes,
my lord.
139.
139.
Give me this. Give me this. Yes.
Page section 138 states, my lord, delegation of powers to the Deputy Commissioner, Subdivisional Officer, or any other gazetted officer. The state government may delegate any of their powers under this act or rules framed thereunder, except where expressly provided to the contrary to any government officer of gazetted rank. In this particular case, my lord, the state government has delegated its powers under FR 15 to the Deputy Commissioner. And as far as the second part is concerned, my lord, except where expressly provided to the contrary, there is no such contrary provision in the entire act, my lord, which basically prohibits the state government from delegating its power to the Deputy Commissioner. So whatever has been done under the ambit of this act, as well as the FR rules. The state government is empowered to transfer, and accordingly, it has delegated its power. Section 30, FR 15, and section 138, my lord. If read all together, this notification, which is at page 24, stands valid.
Yes.
Yes, but so far the section, subsection 1 of 138, it will also kindly come to that the state government may delegate any of their power. That means power of the state government can be delegated under this act or rule except where expressly provided to the contrary to any gazetted officer. Well, power of the state government can be delegated to any gazetted officer. That is, there is no question on that. That can be done. But here, this is the power of the director or the lordship commissioner, as the case may be, lordship in the case of provincial panchayat employee. He is the appointing authority. So he is the transferring authority. So here in subsection 1, power of the government can be transferred to the
gazetted officer. In subsection 2, power of the deputy commissioner lordship can be power of the deputy commissioner or the subdivisional officer.
Two says except.
Except.
Then read everything. Don't read.
Except where expressly provided to the contrary, the government may delegate all or any of the powers of the deputy commissioner or the subdivisional officer under this act or rules framed thereunder this act to any government officer of gazetted rank. Meaning thereby, lordship, the government can transfer the power of the can delegate the power of the deputy commissioner as well as the power of the subdivisional officer to any gazetted officer. Here is also lordship, so far the power of the director is silent. In the third subsection, lordship, except where expressly provided to the contrary, the deputy commissioner or the subdivisional officer, as the case may be, may delegate all or any other powers under this act or rule frame under this act to any government officer of gazetted rank. My lord, so far subsection 1, 2, and 3. 1 says about the power of the government. 2 says about the power of lordship, the deputy commissioner and subdivisional officer. The
In your case, only subclause 1 will apply. 2 and 3 won't apply.
Let me submit it. You submit your part. My lord, so far
my humble submission as his main contention, his main angst is against this impugned notification, which is at page 24, wherein the state government has delegated its power to transfer to the deputy commissioner. So the state government, the powers which are vested in the state government under FR 15 have been vested to the deputy commissioner by exercising.
Tell me where is the appointing authority? Where is the appointing authority?
Yes, appointing authority is the director, Commissioner PNRD, section 30, my lord.
Section 30.
Section 30. As far as provincialized employees are concerned.
Section 30.
Page 46.
Of the Panchayat Act.
Last 2 lines. There shall be secretary and other staff as may be prescribed by the government in every Gaon Panchayat, who shall be appointed as provided in section 141 and or deputy government time. Next, lordship important. In respect of the provincialized employees, the petitioners are provincialized employees. The director of Panchayat and rural development shall be the appointed. So
you are provincialized employee.
My lord, there is no dispute on that. And
so what is wrong?
My lord.
So can't the government make a thing?
Government can transfer, my lord, under FR 15.
My lord, power of the government can be lordship delegated, but here lordship, power of the director, whether the power of the director can be delegated by the government, that is the core issue in this case, lordship. Here, so far, subsection 2, power of the deputy commissioner, subdivisional officer can be delegated. Power of the government can be delegated.
So his case is basically,
that is
can an executive instruction override the provisions of an act?
My lord, in this particular case, the authority that has passed this order is a superior authority to the commission.
No. That is not the law is this. When the act provides that something has to be done in a certain manner, can that provision be overridden by an executive order?
As far as the
or would there have to be an amendment to the act?
As far as the appointment is concerned, section 30 is very clear that the commissioner is the appointing authority. But as far as the transfer part is concerned, the act is completely silent about it. They're completely silent. So as far as this particular silence and void is concerned, FR 15 talks about it, my lord, fills it, stating that the state government may transfer a government servant from one post to another. FR 15 is filling that silence in the act. Page 28, FR 15.
Yes, you tell me now. He's a government servant, provisionalized employee is a government servant. Now, where does it say that only an appointing authority can transfer?
Yes, lordship.
Where does the law say that only an appointing authority can transfer? Supposing a constable is appointed by the SP or police usually, or commandant or whatever. Why can't a DIG or a IGP or a DGP transfer that constable? Why can't a transfer be made by a higher authority?
They can recommend for transfer.
No, but where does the act bar the order of transfer? being made by a higher authority. Where is the bar?
My lord, so far the delegation of power is concerned. That has made it clear. That
There is no bar.
those power of those officers can be delegated.
No. Where is the bar? Where is the illegality or perversity in a transfer order being issued by a higher authority than the appointing authority?
No, this transfer order has not been issued by the higher authority. Power has been delegated to the deputy commissioner, and deputy commissioner lordship has issued the transfer.
Power has been delegated.
Yes.
No, so where is the bar? Once the delegate, okay. So
One of the power that has been.
just a minute. So director is the appointing authority. Now, director is the appointing authority. Now, the transfer is by the deputy commissioner.
Yes.
Deputy commissioner is equivalent to director?
No.
Then who is higher in that?
Deputy director is higher.
No. How do you say that? On what basis do you say that? On what basis do you say?
Is not the
And this director is now a commissioner.
Commissioner.
Commissioner of what?
Commissioner PNRD, my lord, Panchayat and Rural Development.
My lord, the director has been designated as commissioner. And lordship, the commissioner, deputy commissioner is not the departmental authority.
I don't know, where's the bar?
My lord, there is no express bar. The bar is in his argument, my lord. As far as the act and the rules are concerned, there is no bar. In fact, the state government has been empowered by the rules to transfer the government servant, in this case, the provincialized employees, from one post to another.
Yep,
So
can be,
its
but the
powers
government
under
has not
FR15, the power of the state government under FR15 has been delegated.
Yes, so the government's power to transfer is not taken away by the act.
No,
not taken.
And then once they have entrusted the deputy commissioner to
Yes,
do
yes,
their
that-
work
that
for
is-
them, then where is the bar?
So that is the question, lordship. The government, they are the
And
higher
I-
authority, they can do.
I don't find any bar.
Deserves dismissal, my lord.
And so far delegation of power 138 power delegation regarding the power of commissioner of director, that is silent.
No, you see, where is the bar for the government to transfer a person? If there is no bar for the government, how does it matter if the government delegates its power to somebody? Where is the bar for the government to? Okay, let me ask you one question. Can the government say a secretary or a joint secretary? Is the government?
My lord.
Can the government transfer a person other than the commissioner of PNRD? Can it transfer? Can it transfer the Gaon Panchayat secretary?
And so far government is concerned, lordship,
There is no bar.
they are in the line of the department, lordship. They can do.
Then,
But so
and
far
so
the
if
deputy
if they delegate their power, what is wrong?
and that's superseding the departmental authority, lordship.
No, where is the departmental authority?
My lord,
Where does it say?
My lord,
That it's
departmental
only appointing authority. Transfer can be done by the government.
government, that's
So they're delegating their power. Now, if you say that the delegation is illegal, on what basis is it illegal? What is the what provision of law has it violated?
So far as the delegation of power, lordship, is prescribed under this act, where the delegation of power in respect of commissioner or director, it is silent.
Wait, have you missed out something? Have you missed out something? Anchalik Panchayat and Gaon Panchayat are different.
Different.
He is functioning under the Gaon Panchayat. Anchalik Panchayat though doesn't come into the picture in this case. That is chapter 5. He is governed and he's coming under chapter 4.
And Gaon Panchayat is below Anchalik Panchayat, is it?
On a 3-tier system, Gaon Panchayat is the
Lowest.
base. Is
And
at the
then
base.
Anchalik.
Zilla
Anchalik, then
Parishad,
Zilla Parishad.
Anchalik Panchayat and Gaon Panchayat.
3-tier.
I don't know, I don't find it.
Up to your lordship, because my submission would be that since the power of delegation is given in the act.
Power of delegation is given.
Given in the act, but so far the
Which power? 138.
138. And so far the power of commissioner or director, the same is silent. Power of government can be delegated, power of the deputy commissioner and SDC will can.
So where does it talk, where does this Panchayat Act talk about transfer?
There is no such.
Then, if it doesn't talk about transfer, then the delegation of power under the act, there's nothing wrong with delegation of the power of transfer when that is not barred by under the act. Right. Heard, Mr.
M. Khan.
M. Khan, learned counsel for the petitioners. And Mr.
Pavlov, PAV
My lord, petitioner
on behalf of Cape One.
petitioner number 2 and 4. They are in the verse of retirement, lordship.
When are they retiring?
Lordship, already the authority has issued the order after.
When are they retiring?
Yes, lordship, I think. In the month of December, lordship.
December of this year?
Lordship, I'm giving the date, lordship, I have to stake in my petition.
We'll ask them to reconsider the case.
Already, lordship, reconsider in terms of.
And reconsidered and allowed.
Allowed. Paragraph 13, I have stated.
But when are you retiring? This does not say anything when you're retiring.
Already retired as per.
We don't know unless you give out, you really mention you give some supporting document. How can we say that you're retiring in December? You might be retiring in December 25, then what happens?
Why not, in the petition already I have stated that one is going to retire on 31 seconds.
Where?
Paragraph 13. That means,
Paragraph
lordship,
13.
both the petitioner has already retired.
They've retired, both retired.
Yes.
Then, in the end of the matter,
In respect of petitioner number 2 and 4.
where have you mentioned?
Paragraph, page 11, para 13. lordship.
Both of them are retired.
My lord, that
Then
is
nothing remains.
after interim order.
Nothing remains. Heard Mr. M. Khan, learned counsel for the petitioners. And Mr.
Lord Pavlov on behalf of Cape One, PNRD.
Mr. Pavlov, PL.
PAV.
What name is that?
Lord,
Russian name or something like that? Huh?
Russian.
Huh?
Russian, my lord, origin Russian.
You're Russian, partly.
No, my lord,
What?
I'm hardcore Assamese Ahom, but my father named me Pavlov.
Why you were born there or something? Nothing. Just like that.
Literature.
Like some of the names given in Meghalaya. Huh? Forget me not types.
Forget me.
We had a schoolmate, one day junior. Name was Forget Me Not. Anyway, so appearing for such and such. Huh? The petitioners hearing have challenged the impugned order dated 22/5/2023 issued by the Deputy Commissioner Kachar transferring the petitioners who are Gaon Panchayats
As well as the lordship notification page 24.
Page 24.
My lord.
The petitioner's case is that the delegation of the power of transfer to the deputy commissioners. No, delegation of the power of transfer of Gram Panchayats, Gram Panchayat secretaries by the deputy commissioners by the notification dated 17/5/2023 issued by the secretary to the government of Assam, Panchayat and Rural Development Department. Has to be set aside as the same cannot be as the delegation as the power to transfer cannot be delegated to the deputy commissioner of a district in terms of section 30 bracket 1. Read with section 138 bracket 1 of the Assam Panchayat Act, 1994. Hereinafter referred to as the 1994 Act. That's all. The counsel for the petitioners submits that that in terms of section 30 of the 1994 Act, the director of Panchayat and Rural Development, who has now been designated as Commissioner of PNRD, shall be the appointing authority of the provincialized Gram Panchayat secretaries. He submits that in view of the above, section 30 bracket 1, it is only the Commissioner PNRD who can transfer Gram Panchayat secretaries and not the deputy commission. The learned counsel for the petitioner further submits that in view of section 138 bracket 2 of the 1994 Act, wherein it has been stated that except where expressly provided in the contrary, the government may delegate all or any of the powers of the deputy commissioner or subdivision officer under this act or rule framed thereunder to any government officer of gazetted rank, books, the power of delegation has been given to the government. However, the power to delegate the power of transfer by the government to the deputy commissioner is absent in the 1994 Act.
My lord.
In view of the above, the impugned transfer order having been exercised, having been made,
Something is here.
huh?
The power of lordship government to delegate its power to the commissioner. Lordship, that is there.
Uh,
But so far the power of the commissioner or the director to the deputy commissioner is silent. Power of the government can be delegated to the deputy commissioner, but the power of the director or commissioner is silent.
Okay, what have I said? The last sentence? To the deputy commissioner is absent. That's what I said. Comma, though the power to delegate to the, however, though the power to delegate the government power to the commissioner slash director of PANRD is present. That's what you're saying. What are you saying then?
My lord, my submission is there. The government has no power to delegate the power of director
Okay.
to the
Well, so though well, not though, from though you cut, huh? For some. Thus, the government has no power to delegate the power of the director slash commissioner PNRD
Yes.
to the deputy commissioner.
Yes.
In that way of the matter, the impugned order dated 22/5/2023 and notification dated notification dated 17/5/23 should be set aside. Next, on the other hand, Mr. Pavlov.
Pavlov, my lord.
Pavlov what?
Handy.
They put that in the beginning, yeah, yeah. That you have made the name or your parents gave you the name?
My lord, my parents have.
Pavlov Handik. On the other hand, Mr. Pavlov Handik, the learned counsel for the state respondent, submits that FR 15 gives power to the state government to transfer a government servant from one post to another. He also submits that Section 138(1) of the 1994 Act allows for the state government to delegate any of its powers of transfer. Any of its to delegate its power of transfer to any government officer of gazetted rank. As the deputy commissioner is a government servant of gazetted rank, there was no infirmity with delegating the power of transfer to the deputy commissioner. He also submits that there is nothing in the 1994 Act to show that the state government has delegated the power of the director slash commissioner PNRD to transfer a person to the deputy commissioner concerned. To the deputy commissioner. he accordingly submits that there be no infirmity with the transfer order and the delegation of power of transfer to the deputy commissioner the writ petition should be dismissed. Full stop. I have heard the learned causes for the parties. Full stop. A perusal of the 1994 rules shows that there is no specific provision which provides that only the director of Panchayat and director of PNRD, who has now been designated. Now, who is the appointing authority and has now been designated as the commissioner of PNRD? What do you mean designated? That PNRD, that appointing authority power has been given to the commissioner.
Rename, just a rename.
Or just the rename.
Just a rename.
Who has now been designated as commissioner PNRD. What have I said? Just read. PNRD, who has now been designated as the commissioner of PNRD as the appointing authority, has the power of transfer of the Gan Panchayat secretaries. Full stop. Full stop. As such, keeping in view the provisions of FR 15 read with section 30 of the 1994 Act, this court does not find. This court is of the view that there is nothing, that there is no bar for the government to transfer Gan Panchayat secretary. Further, section 138 of the 1994 Act provides that the state government may delegate any of its powers under the 1994 Act or rules framed thereunder. Except where expressly provided to the contrary to any government officer of gazetted rank. Thus, the 1994 Act, that thus any power of the government or the state government under the 1994 Act can be delegated to any government officer of gazetted rank, except where expressly provided to the contrary. In the present case, there is nothing to show that the state government cannot transfer any Gan Panchayat secretary. Section 30 of the 1994 Act only provides that the director of PNRD shall be the appointing authority, and it does not specifically bar the state, it does not make any bar for the state government to transfer any Gan Panchayat secretary. As such, on a combined reading of FR 15 and Section 138 of the 1994 Act, I am of the view that there is no bar for the state government to transfer any Gan Panchayat secretary. As such, the delegation of the power of the government to transfer a Gan Panchayat secretary by the impugn order dated, by the impugn notification dated 17/5/2023 does not, is is not in violation of section 130 of the said act. Full stop. Consequently. This court does not find any infirmity with the impugned order transferring the Gaon Panchayat secretaries. Consequent, the repetition accordingly dismissed.
A small line may be added at my lord's discretion, as per my lord's discretion. The petitioners, the remaining petitioners may be directed to join their new place of
Already
posting. Already. Silence. Obliged.
Lordship, on the last one, there was a direction to obtain instruction from the Department Government of Assam, Lordship. We have received instruction, Lordship. We are going to file our affidavit, Lordship, in about 3 weeks time.
Mr.
P.N. Sharma.
P.N. Sharma, learned counsel for the Elementary Education Department, submits that he has received instructions and will be filing affidavit in opposition within 3 weeks. Since the matter of 3 weeks.
Lordship.
All right.
My lord, in this matter, we are appearing to the LICA.
That is respondent's number?
6 and 7. We are required to file an affidavit. My lord, can your lordship give us 2 weeks time so that we can file?
I'm appealing for 1, 2, and 3.
1, 2, and 3.
We have already filed here.
You have already filed. Okay, Mr. Your name?
B. Burman.
P. Burman.
DP.
B. Burman, learned counsel for the respondents number 1, 2, and 3, submits that he has filed affidavit in opposition. Mr. S. Datta, learned senior counsel for the respondents number 6 and 7, is granted 2 weeks time to file affidavit in opposition. Mr. S. S. Roy, learned counsel for the respondent number 5, submits that he will not be filing any affidavit. Submits that he will not be filing any affidavit. Full stop. What about 4?
4 is not appearing. So.
Full stop, right.
My lord, in place of 2 weeks, the lordship give us 3 weeks.
Okay, 3 weeks. Then you write next para. A office note dated 2006. No, office note dated 2/6/2022 states that. No, don't say that. That's right. Order dated 8/6/22 states that notice is complete in respect of respondent numbers 1 to 4. However, the learned counsel for the petitioner had been directed to take fresh steps for service of notice upon the respondent number 1 to 4 by registered post with AD within 4 days. As the respondent number 1 to 3 has entered appearance, fresh steps for service of notice upon the respondents number 1 to 3 is not required. Any further? As the respondent number 4 had already been issued with the notice, the second paragraph of the order dated 8/6/2022 is hereby recalled. There's some confusion in the. List this matter after 3 weeks.
Your lordship, my senior is on leg in another court. The matter may be passed over for a time being.
Lordship, here also we received our instruction. We have to file our.
Just a minute. What is the case here? Oh yes, what is the instruction? Let us see your instruction. Let us see your instruction.
Lordship, just now I have received it. It's a case of in charge headmaster Lordship. There is an allegation of misappropriation of midday meal fund as well as the school funds. And the petitioner is alleged to have not furnished the accounts details during even the inquiry committee, before the inquiry committee, as well as during the audit also Lordship. So we need to file our affidavit.
Yes, what to do?
So my signature.
Legs.
Another court.
Let us wait.
Lordship.
Yes, next. Yes.
For license.
My lord, kindly see last order, Lordship. Let's see, 2019 Lordship did this.
Yes.
Lordship, I have pursued the matter, Lordship. Now the budget is available with the health authorities, my lords. They have communicated to me today itself that if they are given 3 weeks time, Lordship, they can start making the payment because the budget is available with them. So there is a long list of people, Lordship, petitioners, along with other people are there who have a lot of payments have to be made, more than 300 groups of people, my lords. So there's a verification process which is going on, but the budget is available now. Initially, finance department, there was a proposal sent on the last date, my lords, and no.
Why 3 weeks?
Within 3 weeks, because Lordship, it can be 2 weeks also, but they're just asking for time because within 3 weeks, they'll be able to show what all steps have been taken regarding payment to the petitioners or the other entitled parties also who have not been made a party, my lord. That is the only. If
My lord, 2 weeks, my lord, no problem. But there is no willingness to pay the my lord amount.
No, Lordship. Now I have.
My lord, last order, on the last order, what was submission? On the last
Lordship
order,
may see the last
as
order.
you have proposal is required. My lord, today is the different submission or Lordship.
Yes, Lordship, that time the proposal was sent to the finance department for concurrence. Now the budget is available with the health department, my lords. So I have been informed by the authorities, Lordship, I do not have it in written, but the joint secretary has conveyed to me that they are already starting, they're just verifying as to the entitlement.
What is this fixation of ceiling?
Lordship, when there's a ceiling amount, like a budget is provided, and then if it exceeds, then a ceiling proposal has to be sent, my lords. So, my lords, that budget is also available at the moment, my lords. So, Lordship, if I may request, Lordship may fix it after 2 weeks. Within 2 weeks, we'll show you. We can show the court, Lordship, that the payment have already been made, my lords.
Let us.
Definitely, my lord, recorded.
That
Okay, right.
statement will be recorded.
Mr. H. Aliha, Learned Standing Council Finance Department submits.
And health, my lord.
The Standing Council Health Department submits that the amount of rupees, that the budget amount of rupees 6720.00 lakhs has been made available to the department, to the health department. So he submits that as per instructions received from the joint secretary, health department, comma, verification will be started and amount will be disbursed. Accordingly, placed for
2 weeks.
2 weeks time.
After 2 weeks.
List the matter on. Give a date, 2 weeks. Earlier.
Lordship,
Earlier.
slightly, Lordship, that first of
You
December.
wanted 2 weeks. Today's what date? 15.
Oh, Lordship, 2 weeks.
111, I appear to the response number 2.
Mr.
Das.
Das, what have you got to say?
Same prayer,
Year for which?
I'm for the response number 2.
Who is respondent number 2?
Chief Secretary.
Yeah. Okay, Mr. Das appears for respondent number 2. Huh? Put that somewhere.
111.
In the contempt case number
452.
452 of 2023.
My lord, date is lost. Lordship, all right.
Future Lordship. Lordship, this is a contempt petition, Lordship, wherein Lordship, the Honorable Single Judge has directed. Lordship, it is the effective portion is in page 56, Your Lordship. Lordship, what happens, Lordship? Honorable Single Judge has directed the respondent authorities to pay a monthly salary. Page 56, para 58, Your Lordship. These are the 5 directions, Lordship.
And
Yes, what are you going to do?
eventually, Lordship, they have paid Lordship. But for the current, in my instruction, Lordship, current month, on the last month on October 19th or 20th, they have received pension for 1 month. They have received their.
So we cannot keep this case pending all the time. Every time, so this will carry on till you
The
get
whole
pension
directions
till
are
your
not
death.
not implemented, Lordship. The whole other directions are not implemented. I should be, Lordship, there are arrears to be paid, Lordship, since 2013, Lordship. There are arrears to be paid. It is mentioned in the order, Your Lordship.
Yes, have you paid the
I'll
arrear?
explain the question,
No,
Lordship.
there is no arrears.
Just a minute.
Lordship, a total of 101 crores was required for payment of the entire arrears with pension, regular pension plus arrears up to 2023-24. Whatever government for the time being has paid 18 crores only.
1800.
Still 18 crores. University will go on paying. After that, it will again be up to the government to release further. But only 2 months payment have been made. So in my humble submission, Lordship, the content can be closed, Lordship. This petition can be closed because payments have been made last month, also this month. And it can't go on for every month, payment will be made to.
No, pension to every month it has to be paid.
It is been paid. It has been paid for 2 months. But finally, it will remain on the fund. When the government pays the fund, the university will release it. They've already started doing it. For a few months, it can go on like this. After that, the 18 crores will dry up.
Yes, sir.
Then the government has to make again further. So subject to that direction to the government to make the funds available immediately. Or in the way so that pension doesn't stop.
So, so you have given for October, you have given.
Yes, October, November, so 2 months. I've just confirmed from the year. 2 months.
November also you have given.
Yes.
Then what remains?
Lordship, but in my humble submission, Lordship, kindly go through the Lordship directions, Lordship, of the Honorable Single Judge, Your Lordship.
What about the area pensionary dues, area?
Area will be paid accordingly, Lordship. 18 crores, they are going to pay some.
Unless and until you pay the arrears, then the contempt still is there.
But then that will depend on the fund made available by the government.
Then the contempt will carry on. How can we just close it when you have not complied with the order?
This will not shift in that case go on for the entire year.
Actually, it will go on.
Entire year it will go on.
It will let it go on. What to do? Then we'll ensure that some of you go and spend some time, free food, free lodging.
What will happen is, let's say, there's no obstacle now. After that, fund has to be available, the university will 18 crores have been paid, some around 80 crores are here.
At least you pay the arrears.
That's up to the government. So I'm for the university, I can commit only up to this much.
That is what now. Why can't you pay the arrears? How much do you need for the arrears?
Arrears is total arrears is 80 crores. Lordship.
80 crores.
82.13 crores. Lordship. Where are the year? And, for 2023-24, 19.78 crores was required, but only 18.
Yes, good for the government.
Regarding area loss, it's an installment payment.
Whatever, but you have got to pay.
Will be done by the university.
Provided you provide the funds.
Lordship, already 18 crores something is provided.
He says that the arrears amount to 80 crores.
Lordship, 80 crores at a time they cannot pay 80 crores. So they have adjust from that fund, Lordship.
So when can you pay?
Lordship, already that was already released, Lordship, that fund.
Mr. Council, don't try to, insult your own intelligence and my intelligence. Please, there's a limit. There's a limit to trying to be too
Lordship,
smart.
I am not saying that, Lordship. I am saying that, Lordship, that area should be paid in the installment. Honorable Court does not direct that the whole you have to pay, Lordship. Government has initially released, Lordship.
The High Court has not said that you pay in installments either. Whereas it said in the order that it should be paid in installments. Please read. Where does it say it should be paid in installments?
My Lord, may kindly pay us page 57 also.
Yes.
Paragraph 5 laws.
Yes. Okay, to release the area pension by way of adequate installment. Area pension.
So lordship, some fund is released by the government, so they have to adjust from that lordship. And lordship, if then if that fund is lordship dry up, then government will.
Okay, now number one is,
Lordship.
they have got to pay regular monthly. That is being paid.
That has been lordship
That
already
is being paid.
started by
Number
the
three, the government will finalize MOU already filed with appropriate terms and conditions to provide. Has this
That
been
was
done?
done lordship.
Now,
After,
number four, Dibrugarh University will prepare necessary chart.
that was also done
Has
lordship.
done.
That was also done
So it's only the last part.
lordship. On receipt of the such budget estimate, government will provide the budget either as a grant in
But
aid.
then you have, but how are you going to go? You have not given any amount. They have not received any arrear. Even first installment you have not given.
Lordship, that part will be done by the university. Lordship. Our part is lordship, we have to release the fund lordship.
Correct.
Some
Unless you release the fund, how can they do their part?
some fund is already released by the government lordship. They have to adjust some area from that lordship.
Some areas may be released, but that will be around 20% only because
So you give them at least some, then
that they are doing this month, probably they'll be able to release something.
then
Maybe
we'll
around-
list
I
it
have
next.
talked to them, they are in the process of paying
We'll
some
list it
areas.
next month. If you release some arrears, then maybe we can disclose this contempt. But without that, it cannot be done.
Yes,
Right. Mr. R. Goswami, Learned Counsel for the Dibrugarh University, submits that that area pension has not been paid till date, even by way of installment. In terms of the order, in terms of para 57 bracket 5. No, it is not para 57 bracket 5 of the judgment and order dated 19/5/2021. Passed in WPC 2190 of 2016. He submits that some areas, some area payment will be made within this month. List the matter. Yeah, next week, next month.
Instead of
Next month, second week.
my lord, instead of para 57 lordship may indicate para 58 lordship. Para 58.5 lordship.
58.5, para 58.5. 612, Mr. By then you release some amount.
Petition, we can in touch.
That's what I'm saying.
Yes,
You're
I
asking for adjournment.
Not gone to the.
Okay, right. Miss K. Devi, Learned Counsel for the petitioner, submits that the writ petition can be closed as the matter has become infructuous. Mr.
A Chakraborty.
A. Chakrabarti appears for respondent number
1 to 4.
1 to 4. Full stop. In view of the submissions made by the counsel for the petitioner, which is also agreed to by the learned counsel for the respondent number 1 to 4, the writ petition is dismissed as infructuous.
Highly obliged.
Hmm? 90? 39.
May I please, your lordship? Lordship, your matter is to non-payment of pension, lordship.
Yes, madam.
Lordship, petitioner's pension paper was returned by the AC lordship on the ground that without the approval of the government lordship, his regulation was done by the PHC department.
So?
Lordship, here lordship, whatever initial appointment of the petitioner was as a workers employee in 1990, 4/1/1990 lordship. And on lordship, 1/4/1990, the petitioner and some other workers employees were deputed to.
For 1990.
1990 lordship. After 3 years.
In which department?
Lordship in the Assam, lordship, Assam Urban Water Supply and Sewage Board.
Assam?
Assam Urban Water
Urban
Water Supply
Water Supply
and Sewage Board.
and Sewerage Board.
Yes, Lordship, on
So this is not even a department, this is a board.
board, Lordship. On 1/4/1990.
1/4.
1/4/1990, Lordship. And in the board, Lordship, he was promoted to the post of pump operator.
On
In 1997, Lordship, he was promoted to pump operator in the regular scale of pay.
this is still in the board, it's not a government department, is it a government is it a government
Initial, he is appointed in PHC department, Lordship. From PHC, he was deputed. As per their own language, Lordship, it was deputation.
No, he was, is he PHE appointed as what?
As WS Khalasi, works as Khalasi, Lordship. Lordship, can you see the appointment letter?
Work
Lordship?
charge Khalasi.
Khalasi.
When?
On 1/4/1990.
4/1/1990, then? You
Then
said 1/4/1990 or something happened.
he was deputed in board, Lordship.
Deputed?
Deputed, Lordship. And in the board, Lordship, he was promoted to
But
pump.
he's not even a government servant.
Yes, Lordship.
Then,
And but the Lordship,
okay, then what happened? Then what?
Lordship, yes, in 1997, in the board, he was promoted to the post of pump
Pump operator,
operator
then?
in the regular scale of pay. Thereafter, in 2011, Lordship, as per the cabinet approval,
2000?
2011, Lordship.
What 2000? Which date?
Date, Lordship, 6/4/2011. The
What happened?
notification was issued, Lordship. Page 26.
Page
Notification-
36,
Page 26.
26.
26. Notification was issued by the additional chief secretary engineer PHC to the effect that as per the cabinet approval of the government of Assam, these deputed employees were reverted to the parent department, that is the PHC, Lordship.
Where is your name?
Yes, Lordship. My name is P.S. Lordship 27, serial number 43. 45, serial number 45, Lordship, Parisharan Haloi.
Eh,
Then, Lordship, on such reversal, Lordship, he was again known as WS Khalasi, but it was the board later on corrected it that he was not Khalasi, he was promoted as pump operator.
where is that?
It is
Where is the
page 30, Lordship,
page 30?
page 30. May I read, Lordship? In continuation to the above, it is stated that the managing director Assam Urban Water Supply and Sewage Board has informed by his data insurance show that some of the reverted employees were promoted, placed with higher responsibility during their tenure in Assam Urban Water Supply and Sewage Board. As the post held were shown in the notification, that is the 2011 notification, Lordship. As per earlier communication from now this may please be read as per list enclosed for WC and MR concerned to your office only. From the date of their joining, all other conditions remain same. Proposal for their regularization and detention, etc. may kindly be submitted at its earlier. So, in this list, petitioner's name is at page 31, serial number 23.
Yes, then?
It is shown as WS Pump.
Then what happened, madam? Then what happened?
After that, Lordship, he was retired from service on 28 to 2019. Page 32, Lordship, he was informed that his date of retirement is on 28 to 2019. Then, Lordship, on 15/3/2019, page 34, Lordship.
Yes.
By this order, Lordship, petitioner service was regularized with effect from 27 to 2019. Page 34, that copy. After that, his pension proposal was
Regularized when? 15/3.
by order dated 15/3, 2019.
with effect from?
With effect from 27 to 2019
Then this is by the, written by the E.
by the, yes, Lordship, Executive Engineer PhD.
Where is the government, government order approving that you should be regularized?
Lordship, thereafter the pension papers were sent to the AG Lordship, and AG order is at page 36, Lordship. Last 4 line, Lordship. So the and in respect of position Halloway regarding regulation of service of this office has already regularized his service by letter dated 15/3/2019, and he has retired on 28/2/2019. The AG has returned back the pension papers to the concerned division as the regulation of works as service required prior approval from the government. After that, Lordship, as per the affidavit filed by the AG Lordship, government has not submitted any proposal in this respect. Now, Lordship, the
Yes, who's for the PhD?
PhD department has admitted the petitioner's case, Lordship. They have not disputed any of the spectral.
No, it's not that. It's, why should they dispute?
Lordship,
Yes, where is the government approval for the regularization of the petitioner service?
Lordship, in our affidavit at para 16, we have para 6. We have mentioned that actually it was under consideration.
It was under consideration.
Yes, but
So no approval given.
in principle, Lordship, there was no approval.
Lordship, this order of page 20 is page 34, Lordship, originally is page 35. This is an order regularizing the
Page
petitioner's-
30?
Page 34, Lordship. Annexure H. This is
Page
an,
34.
yes. Originally is at page 35. This is not eligible. This is an order passed by the,
Adam, that much we know. PHE is in your favor.
yes, sir.
But PHE, this E is not the government, neither is the chief engineer. The government approval is required. You see,
Petitioner is working under executive engineer, Lordship.
maybe, madam, maybe, but executive engineer is the government.
Lordship, the petitioner was appointed in 1990. And from the appointment letter, Lordship, may kindly see the appointment letter. His appointment is not in the nature of works as employee, Lordship.
Madam, I agree. The problem is that the approval has not been given by the government. If approval is not given, then what happens? Does it mean that approval is given? If approval is not given?
This is the official order, Lordship.
Maybe, madam, maybe.
Official order, their order.
Can this is by the E. Supposing, now let's come. Supposing, can a JE regularize your case?
Lordship, in their affidavit, they have stated that this is a.
You're not understanding the question.
Yes, Lordship, but
You're not understanding.
regulation has been made,
I'm trying to reason with you. You're not even trying to understand. So why should I? Yes, so yeah, so where is your affidavit?
Lordship, we have filed an
Yes, where is it? Page?
page para 6, page 3 of the affidavit.
Page 3, para 6.
It was Lordship actually under consideration, but somehow the office of the chief engineer passed this form.
This is wrong. If there was no approval from the government, the regularization order of the E has got no force in law. Only thing is that you should take a decision. Let the secretary, who is for the secretary PhD department?
Lordship, I am.
You're the one, no? You're appearing for the JE also for everyone.
The entire department.
Then you take a decision on this, and then you've got to take not only you take a decision on this, on regularization. And depending upon that, and of course, depending upon that, then maybe she can get. But you cannot get anything. There's no approval.
Let's say, can you see the appointment letter, Lordship? This is, this appointment letter is not for the workers, though it is mentioned that it is an workers employment, Lordship, but his appointment is not against.
Madam, you are appointed. We do not know. Let us see your appointment order. Page
Yes, Lordship, page 19.
Page?
Page 19, 119.
19.
Against the scale of pay, not against any project or scheme, Lordship. And for last 30 years, he served in the
The
department.
following MR labor are hereby allowed to officiate as W charge.
Officiate, Lordship, as
Huh?
obvious, allowed to officiate.
Yes, officiate
workers-
means what? What do you mean by officiate?
Lordship.
Officiating is never a regular appointment.
Lordship,
And you are a MR laborer.
as the WS
No,
Khalasi,
no, you have got no case.
Lordship, in the regular scale of pay, in the scale of pay
Maybe,
also-
maybe.
And workers employee is not, Lordship, deputed or promoted, Lordship. It is against any scheme or project.
You are a work charge employee, madam. Work charge employees are never regular employees.
Otherwise also, Lordship, all the similarly situated employees already got regulation and also pension. Only the petitioner has been left, Lordship.
Correct. Only problem is they have not taken a decision.
Yes, Lord.
One thing is that he has worked for 29 years. Cannot leave him in the lurch.
Lordship, there is one more issue. Actually, while the petitioner was deputed in the sewerage board, the petitioner was promoted to some other post,
Pump operator.
pump operator, and Lordship, that board is not a party here, so perhaps the board.
That is the promotion made there. I do not know. There's everything is. There's nothing to show that you are a regular employee.
And also,
How can an irregular employee be promoted? That is an issue there also. If you are not a regular employee, how can you be promoted?
let's say we fulfill the rule 31 of the pension rules because his service was not substantive, but he was serving in a regular establishment of the government, Lordship, against and not against any scheme or.
Were you appointed on the basis of any advertisement?
No, Lordship. This is not.
Then,
This is in 1990, Lordship.
but
Yeah.
the law,
At that
the
time-
law still remains the same.
At that time, it was not.
At the time, there was no advertisement.
No, no,
1990, huh?
No, Lordship. It was regularized after there is provision for regularization after such appointments. And there is also, Lordship, apex court judgment in the Prem Singh case, Lordship, same in the same matter.
What does it
the
say?
Honorable apex court has allowed pension, Lordship.
Let us see.
Yes. Paragraph 30, Lordship. May I read?
Yes.
We are not impressed by the aforesaid submission. The appointment of the workers employee in question had been made on monthly salary and they were required to cross the efficiency bar also. How their services are qualitatively different from regular employees. No material indicating qualitative difference has been pointed out except making bold statement. The appointment was not made for a particular project, which is the basic concept of the workers employees. Rather, the very concept of workers employment has been misused by offering the employment on exploitative terms for the work which is regular and perennial in nature. The workers employees had been subjected to transfer from one place to another like regular employees as apparent from the document placed on record. In Narayan Datta Sharma versus State of UP arising so the appellants were allowed to cross efficiency bar after 8 years of continuous service, even during the period of works or services. Narayan Datta Sharma, the appellant, was Next will be 31. In the aforesaid facts and circumstances, it is unfair on the part of the state government and its officials to take work from the employees on the workers basis. They ought to have resorted to an appointment on regular
Madam,
basis.
please read the facts of the case in para 2. Please read the facts of the case in para 2. Yes, please read.
Yes. It will be highly discriminatory and irrational.
No, para 2.
Para two.
The facts are being narrated from Prem Singh so. The appellant was appointed as a welder in 1965 in a work charge establishment. He was transferred so. His services were regularized on 13/3/2002. He superannuated on so. Then he filed a writ petition to count the period spent in the work charge establishment as qualifying service. It's a different issue. Out here he was regularized, but since his work charge service was not counted for the purpose of pension, he came to the court saying that the period spent as a work charge employee should also be counted for the purpose of pension. It's different from your case. These facts are different. This case does not support you. Out here he was a regularized employee. You're not a regular employee. Where's the case?
In our case, also, since this is an official order regularizing the.
No, there is no regularization. Sorry. Where's the regularization? There's no regulation. You're a work charge employee. Out here, his work charge service was regularized. He was a work charge welder. His service was regularized. However, for counting his pension, the government did not count the period spent as a work charge employee. That's why he came to the court saying that the period spent as a work charge employee should also be counted for the purpose of pension. That's a different issue. Right.
In this case, since they have stated that it is under consideration, it was under consideration, but they have not taken it, and some other authorities have regularized it. So let them take and finally, lots of instruction what they are going to take in respect of the petitioner.
Correct.
Yes.
Let them take a decision on that. And then depending upon the decision, you come to court afresh.
Yes,
because you see, if we leave it pending, no point. One reason, no point, is that they will not take a decision. They will say not taken, not taken, not taken. So we'll tell them to take a decision within a specified time. If they allow your petition regularization, then you have got a case. If you do not have, if they deny you, then you can come to court saying that you have been denied and you pray for regularization.
Next that may be given on that day they may submit their
They will not. They will. Even if they, supposing they.
They will keep it pending, lordship.
No, if they contempt, you file contempt.
Because it is he retired in 2019, lordship, and till that they have it is filed petition is filed in 2021, and they have not taken any action.
Heard Miss R. Devi, learned counsel for the petitioner. Also heard Mr. I. Bhattakur, learned counsel for the PHE. And Mr. R. K. Talukdar, learned standing counsel, AGSF.
For response of 5.
Bracket response number 5. The petitioner's case is that the petitioner who was appointed as a work charge khalasi in the PHE no. The petitioner's case is that you take this paragraph 2 of the order dated 8/12/2021. Thereafter, continue. The petitioner was deputed to the Assam Urban Sewerage at the Assam Urban Water Supply and Sewerage Board on 1/4/1990. Just before that, you just write, the petitioner was also given the regular scale of pay. Huh? Then you say, the petitioner was deputed to so, okay? Full stop. Deputed to so on 1/4, full stop. And was promoted to the post of pump operator on 25/3/1997. Full stop. Next paragraph.
15/3.
Huh?
15/3.
Was 15/3/1997. The petitioner was again transferred to the office of the executive engineer, PHE Nalbari, via notification dated 6/4/2011. Full stop. As the petitioner was wrongly referred to as work charge khalasi in the notification dated 6/4/2011. A correction was made via letter dated 13/4/2011 issued by the additional chief engineer PHE Assam, wherein it was shown that the petitioner had been operating as work charge pump operator. And had been promoted as work charge pump operator on 15/3/1997. Next paragraph. On completion of 60 years, the petitioner was allowed to retire from government service with effect from 28/2/2019. Next paragraph. The petitioner's counsel submits. No, next paragraph. No, don't say that. Thereafter, the executive engineer (PHE) issued a letter dated 15/3/2019 showing that the petitioner had been regularized as a khalasi with effect from 27/2/2019, that is one day prior to his retirement. Full stop. The pension papers of the petitioner were sent for finalization. Full stop. However, the office of the AGSM, respondent number 5, returned back the petitioner's pension papers on the ground that regularization of the petitioner's work charge service required prior approval of the government. Next paragraph. The petitioner's counsel submits that as the petitioner's service had been regularized on 27/2/2019, that is one day prior to his retirement, the petitioner should be granted pension in terms of the judgment of the Supreme Court in the case of Prem Singh versus State of Uttar Pradesh and others, 2019, 10 SCC 516. Full stop. Next paragraph. Mr. I. Bhattakur, learned counsel for the PHE, Assam submits that though the additional chief engineer bracket PHE Hengra Bari Assam had written letter dated 17/6/2011 to the Secretary to the Government of Assam, PHE Department to regularize the services of 27 work charge laborers, including the service of the petitioner, no decision had been taken by the Secretary to the Government of Assam, PHE Department. However, as a representation for regularization had been submitted to the executive engineer, Nalbari division, the executive engineer bracket PHE wide letter dated 15/3/2019 regularize the service of the petitioner in terms of the Assam Service Pension Rules 153, Note 1. Give me the pension rules. Maybe it's in the. Next paragraph. Mr. R.K. Talukdar appearing for the AG, the office submits that unless the petitioner's service is regularized, no pension can be given to the petition. Next paragraph. A perusal of the provisions of the Assam Service Pension Rule 1969 shows that pension can only be given to a regular government servant. However, as can be seen from the submission made by the counsel for the PHE and the affidavit submitted by the executive engineer, PHE Nalbari division, the state government has not given any approval for regularization of the petitioner's service. As such, the regularization of the petitioner's service by the executive engineer is beyond the power and competence of the executive engineer.
That's it. That's it. There is nothing that they have processed the case of regulation. Only they have stated that they have requested for regulation. From 2011, it is pending. After that, what?
Let us see, madam, what will. So we'll give a direction now. That's why we're giving a direction. But we cannot allow your petition. That's for sure, because you have not been regularized. You also, you knew, where is your prayer that you should be regularized?
Because Lordship's
Only
regulation
2000
order is still
because-
existing, Lordship.
Okay, next. In the case of Prem Singh Supra, the appellant therein had been appointed in a work charge establishment as a welder in the year 1965. His services were regularized in the year 2002 and he was posted as a pump operator in the pay scale or in a regular pay scale. Full stop. Prem Singh superannuated in the year 2007. Full stop. Prem Singh thereafter filed a writ petition praying that his service in the work charge establishment be counted as qualifying service for grant of pension. Full stop. In the present case, the petitioner's service has never been regularized. Full stop. As such, the judgment of the Supreme Court in Prem Singh is not applicable to the facts of this case, in as much as the facts in this case and in the case of Prem Singh Supra are different. How is this 153 applicable to you? I don't know. How is this? 153 is talk for something else. So rule 153 of the Assam Services Pension Rules 1969 provides for grant of gratuity not exceeding 6 months' pay by the governor of Assam to a person who retires after rendering many years of satisfactory service as a contingency employee or in any other non-pensionable service. Bracket, other than members of the work charge establishment. Right, close. Provided that no retirement benefit is otherwise admissible to such person under any other specific rule or order applicable to it. Note 1 of 153 of Rule 153 of the Assam Services Pension Rules 1969 provides as follows. Page 190. Is it page 190? As can be seen from the above, there is nothing to show that. As can be seen from the above reasons, there is nothing to show that the petitioner can be granted pension except for gratuity, comma, as he has not been regularized, as his service has not been regularized. Full stop. In that view of the matter, comma, the prayer of the petitioner for grant of pension cannot be allowed. The writ petition is accordingly dismissed. However, keeping in view para keeping in view para 6 and 7 of the affidavit in opposition filed by the respondent number 1. No, respondent number 4. Which is to the effect that the petitioner's representation it is to the effect that the secretary to the government of Assam, PhD department has not and has been asked to take a decision has been requested to regularize the service of the petitioner, and the same not having been done so, comma, the secretary to the government of Assam, PhD department shall take a decision on the request for regularizing the service of the petitioner, which has been made in terms of the letter number PHE-118/ESTT/98/PT-1/3734 dated 17/6/2011, issued by the additional chief engineer (PHE) Hengrabari, Assam. That is that para 6 of the affidavit in opposition of the respondent of the PHE. The secretary to the government of Assam, PhD department shall take a decision on the same within a period of
1 month.
What, huh?
1 month.
1 month.
3 months.
No, Lordship, already pending for last 2 years, Lordship. They have not taken any action.
Within a period of 6 weeks. Within a period of 6 weeks from the date of receipt of a copy of this order, and communicate the decision to the petitioner. The petitions accordingly disposed of. So depending upon that, you can come again. Even if it's denied, then you can ask for regularization.
But this order, regulation order is still in force. They have not, Lordship.
What regularization order?
Lordship.
That I've said is has got no value, has got no relevance.
Yes.
It's got no force.
Yes.
The the E cannot give, because you see, the government has not taken a decision. E is not the government. You are making a mistake. Don't think that the E is the government. She is also not the government. Government will be secretary, under secretary, joint secretary, all those. The E and all, they're not the government. Director is not the government. Keep that in mind.
Lordship.
25 and 26.
Here, my lord, the petitioners, they were employee in the Escort Bank and they were terminated because of excess staff. And thereafter, they filed a petition here in this court, and this court reinstated them. Then the Escort Bank, they went for division bench appeal, and in the division bench also it is upheld. Then went to Supreme Court. Supreme Court simply modified instead of 100%, 50% wages because
back wages.
Yes. Thereafter, what happened, my lord? the State Bank Authority did not release the amount because these petitioners, they were the guarantor of some loan. And that loan is
They were the
guarantor.
guarantor of loans.
Yes. And that loan is were defaulter, my lord. So because of that, the money has not been paid.
So what is wrong?
No, wrong means, my lord, first thing, the money, they have already instituted a Bakijai case, and that case is going on and they have recovered some money. But till exhaust of all the means of recovery, my lord. And only this default, they will be declared as defaulter. On that condition, my lord, money can be recovered from me. Now, process is going on to recover the money from the loanees, and something they have recovered already. Now, my money has been kept in. They said that
Maybe they have not recovered. How much are you supposed to pay?
my lord,
How much have they kept pending?
my lord, entire amount they have kept, my lord, my salary, my lord.
No, you see, what is the loan amount?
Loan amount, my lord, there are two cases. In the in one case, 41 of 1996, the loan total outstanding amount, it is 4,98,000. Then in the second case, 121.96, that is the 12,16,000, my lord. And they have adjusted.
And how much is your how much is your money payable to you?
My
50%.
my salary, total salary, money, it was deducted. In one case, 2,46,998, and in another case, is 2,48,635.
Deducted already.
That they have said that it is adjusted, and in in answering to my letter, they have said that they have kept in fixed deposit. But
what is wrong? You are the guarantor. You have guaranteed that the loan amount will be repaid. So what is wrong?
No, wrong means, my lord, we are the fourth grade employee, my lord.
Maybe this is not regarding recovery of excess pay. This is you are a guarantor to a loan.
They have started, my lord, Bakijai proceedings, my lord.
So
then let them complete the Bakijai proceedings, and if they fail to collect the money,
correct,
then we'll be liable.
So what has happened to the Bakijai case? What is the stage of the Bakijai case?
Bakijai case, my lord, I don't know actually what is the position now, but they have recovered some amount.
Yes, who is for the bank? What to do? Do you know the counsel for the bank?
I have
Mr. H. Roman. This has come after 4 years, this case.
Yes, my lord, after a long period, my lord. It is actually, my matter is 2010, one case is 2000 and one is 2012.
Right. Yeah, Mr. Fukan.
Yes.
We'll give another date, let the bank come.
And in next week, my lord, can you speak?
Not so fast. Mr. K.K. Fukan, learned counsel for the petitioner appears. No one appears for the Ascard Bank, ASCARD. Sir. On the next date, the parties shall inform this court about the status of the Bakijai proceedings that have been initiated against the borrowers of the loan amount, in which the petitioners are the guarantors. List the matter. Give sometime in December.
Net legal action.
In this case, we have received the instruction, my lord. We need some time to file our affidavit.
My lord, I have a specific submission, my lord. This is a transfer matter, my lord.
and my interim prayer, my lord, is still in consideration. Lord, will kindly have a look at the earlier two orders. Order dated, my lord, 6/11/2023 and 18/10/2023, my lord.
6/11, if not received the instruction, my lord.
And my lord,
Incentive-
Lord, will kindly have a look, starting from
Instruction received,
13/9/2023
some
and
allegation
18/10.
regarding misappropriation.
I'll place
of money.
two documents before your lordship. Till then, my lord,
Yeah, have you joined your trans?
no, my lord. There is a, my lord, release order that is passed by the concerned authorities, my lord. That release order has not been passed, and I'm still in my original parent school, my lord.
Why?
Join, my lord. Because,
Now
my lord,
it's,
I'll show it before
2 months
lordship.
have gone. Why
Lordship,
haven't you joined?
my lord, it is still under consideration. My
What,
interim,
what?
my interim prayer, my lord. Since the authority, my lord, they have not passed any, my lord, release order.
No, but then.
I did not join, my lord, accordingly, my lord. Lordship will kindly allow me 2 minutes time, my lord, to satisfy your lordship, my lord. I'll place two documents only, my lord. My lord will kindly have a look at page 20, my lord. Annexure 4, my lord.
21.
20, my lord. 20.
Yeah.
Annexure 4, my lord. My lord, a show cause notice was issued from the block elementary education officer, my lord, with 5 allegations, my lord. Except the, my lord, allegation number 1, my lord. The rest of the allegations, my lord, only on the basis of information, my lord. Not, there was no, my lord, spot verification, nothing, my lord. The concerned authority, my lord, did not conduct any inquiry, my lord. And the allegation number regarding allegation number 1, my lord, that I remain absent for 5 days only. I admitted that, my lord.
And you signed pretending that you.
That I admitted, my lord, replying to my show cause notice. My lord.
So,
Thereafter, my lord, that about leaving apart that, my lord, the other allegations, my lord, were not, my lord, admitted by me, my lord. And accordingly, my lord, this authority, he did not take any decision. Rather, he made a, my lord, lordship will kindly have a look at the last page of the petition, my lord. Last page, no.
have you
Page-
received instructions?
My lord, I have read even. In
Well, the
paragraph
reason-
seven, certain allegation is there regarding misappropriation of money, my lord. So,
My lord, that I have clarified, my lord. I have annexed the, my lord, concerned documents, my lord, the money
I
receipts
may
and
be
everything.
allowed to file affidavit and he will definitely
You file affidavit.
My lord, till then, my interim time, I can
Mister?
be allowed for elementary education.
Is granted a week's time.
My lord.
A week's time to file affidavit of position as he has been given parawise comments by letter dated 10/11/2023. Leave this matter after the week.
My lord, till then, my lord, my interim time may kindly be considered, my lord. Lordship will kindly bear with me, my lord. My lord will kindly, my lord, provide, my lord, some interim protection, my lord.